ata I te whakatūtū, I ata I te whakaritorito. I ata whiwhia, I ata rauia, I ata taonga, hei taonga. Nau mai te ata. Tuturu whakamaho kia tīna, haumia, hui e, tai hie. Nā mino kia koutou, I raurana tērā mā, tutoa mai nei ki tēnei ata. Nau mai ki tēnei rohi nei o te ateawa mi Ngāti Te Witi, nā mihi noi kia koutou, I ngā mate, te wiki, te mana ki tau, I mihi hia ki tangi kia kūparaki hia. Anō re rā. I te kai te rangatira I kōrero, I tīmata te kōrero, tēnā kui, anō re rā, tēnā koutou, tēnā koutou, tēnā koutou.
Thank you very much for that welcome. Just before we get going, I think it's always appropriate to do the health and safety messages first. So do we have those?
Right. In the event of an emergency, please follow the instructions of the council staff. Please exit through the main entrance. Once you reach the footpath, please turn to the right towards Pukura Park, congregating outside Spark Building. And just please be mindful, don't block the footpath for other users. Staff will guide you to alternative route if necessary. If there's an earthquake, drop cover and hold where possible. And please remain where you are until further instructions are given. Toilets are just out here towards on our left. And the cafeteria is available upstairs once you go upstairs and on towards your right. Thank you.
Thank you very much for that. So welcome everyone to hearing 2 for the proposed New Plymouth District Plan. My name is Stephen Daish. I'm the chairperson of the hearings panel, and today I'm joined by Commissioners Kit Littlejohn far left and Tuan Coffin beside me here, and Commissioner McMahon on my right. Before we start, there's a few just matters I'll outline for those that live here in hearing 1. The hearings panel has been delegated authority to hear and make recommendations on the district plan review. And those recommendations will be released in one set in 2022 after the hearings are completed. We have indicated in our minute 5 that was released after hearing 1 that we have decided to release what we're calling interim guidance on the strategic directions chapter. So that decision's been made. We outline that in our hearing procedures. And also for new people here, we are running these hearings under a set of hearing procedures which we consulted on and which basically become our Bible for hearing the procedures. So those are on the council's website, and all of the relevant documents are on that website. And thank you, hearings administrators. I think it's becoming pretty efficient now with those documents coming up in pretty good order. And certainly I'm finding the website just the absolute go-to place, obviously. So keep up the good work. I know it's not easy, you know, putting them together, but I think we're going along pretty well. Now, look, I would also like to perhaps ask for some appearances for today, just briefly. I will start on the Zoom. So I see Ms. Eng and Ms. Rat on the Zoom there. So maybe just one of you introduce yourselves and we'll go from there.
Good morning, Commissioner. Sorry, it's Rebecca Eng here. I'll turn on my video so you can at least see me. Ms. Rat and I are joining just to observe the proceedings this morning before Ms. Rat appears at 10:30 as discussed with the hearings administrators.
Thank you very much, Ms. Eng, and welcome.
Thank you.
So just...
I was going to say, and Maureen, I'm Carolyn Rat, as you know, representing Transpower.
Yeah, Maureen, Ms. Rat, how are you?
Great, thank you.
Good. So could I just go around the room briefly, just pop up and say who you are and who you're representing, so we all know who's who in the zoo this morning. Anybody on the
Bob Ward, surveyor, retired.
board?
Good morning, Commissioners. Keith Holsworth, Canadian Review.
Oswich.
Can I correct this, Mark? Can I correctly happen?
Nice.
More than no, Honorable Wilkie, your relationship team.
Morning, Helen Johnson, Sole Taylor Johnson.
Welcome to Kilburn.
Morena tātou whia mako te kote te aotea.
Ian Ticky, current branch chair, branch survey and spatial.
Thank you.
Yeah, on that's all. That's all survey.
Mr. Sol.
That's Barry, Alan Juffin, that's owner of Juffin Surveyors.
The last thing I need to do as way of introduction is to talk about any issues with conflicts of interests. In our hearing procedures, we're very careful about any actual perceived conflicts in terms of us hearing these panels. We have issued a register of interests. So we've declared various work we've done around the district over the years and other relationships we've had or our firms have with submitters. So those actually on the website, and we've asked for comments on those. Nothing has been received back in writing on our register of interest. So I just wanted to double check everyone's all okay to go today without any problems. Right, there's a couple of gentlemen here, which I'll just get them to introduce themselves when they sit down. We've just done some hello. So I'm Stephen Daish, I'm the hearings chair. So I just want to pop up and say hello and where you're from.
Tom Jackson, Blaine Jackson Surveys.
Mr. Jackson.
Chief Blaine, Blaine Jackson Surveyors.
Thank
Mark Blaine, Blaine Jackson Surveyors.
you very much. All right, I think we're done. Are there any questions before we get underway this morning? I think it's over to you, Ms. Edwards, in terms of just the overview of the two reports we're hearing today, or three reports actually. Yes.
Hello everyone. Good morning, Commissioners. My name is Sarah Edwards and I am the District Plan Lead at New Plymouth District Council. I have considered the submissions on and written the Section 42A reports for Part 1, Introductions and General Provisions chapter and the General Miscellaneous Matters. It is important to note that these reports do not cover the Part 1 chapters relating to interpretation. So these are matters concerning the definition nesting tables, the definitions, abbreviations and glossary, as these will be considered at the relevant Chapter 42A reports and at the end of the hearing process. Starting with the Part 1 Introductions and General Provisions Chapter 42A report, 39 original submissions and 39 further submissions were received on these chapters. These related to submissions on the following matters: introduction, contents, purpose, description of the district, how the plan works, statutory context, general approach, cross-boundary matters, relationship between spatial layers, and national direction instruments. This covers things like national policy statements, the New Zealand Coastal Policy Statement, national environment standards, regulations, and conservation orders. In my analysis of the submissions in the Section 42A report, I grouped the submissions into three key issues, which were issue 1, submissions that are related to matters outside the scope of this topic to be considered in other chapters. Issue 2, general corrections and clarifications. Several submitters put forward alternative wording to help with plan interpretation. And issue 3, which is strengthen and clarify specific content. Having read the pre-circulated evidence in response to the 42A report, I consider there only to be one matter of outstanding contention on this chapter, that being the activity status that applies where an activity covers more than one role. Turning now to the second report that I wrote, which is the general miscellaneous matters. 57 original submissions and 42 further submissions were received that did not relate to any one specific chapter in the proposed plan, and therefore have been grouped together as general miscellaneous matters. The submissions covered a mix of plan structure, points of clarification, general interpretation, and matters for correction. Some submissions received, however, did oppose the proposed plan in its entirety, and some were out of scope. In my analysis of the submissions in the Section 42A report, I grouped the submissions into 6 key issues. These were the issue 1, submissions that set out the scope of the district plan review. Issue 2, submissions that relate to matters outside the scope of this topic, but to be considered in other chapters. Issue 3, general plan structure and interpretation matters. These were points where clarification was sought on interpretation of the provisions. Issue 4, general corrections or clarifications. So these were instances where there was correction of spelling mistakes, amendments to hyperlinks, and general changes to improve the integration and ease of use of the plan. Issue 5 was strengthen and clarify specific content, and issue 6 related to whole of plan submissions. We had submissions that opposed the plan in its entirety. Having read the pre-circulated evidence in response to the 42A report, I consider the key areas of contention on this topic to be the use of cross-referencing in the district-wide chapters back to underlying zone and direction, and second point being direction concerning how the rules and effect standards should be structured. Another point of contention is inconsistencies or gaps within and between chapters. This has been deferred to the chapters that I had identified as being relevant, but one submitter requests that this is addressed now. The use of unique colours for activity statuses, and the request that each activity have its own activity status next to the rule. And finally, whole of plan submissions. 2 submissions consider that there has been inadequate consultation undertaken, and that the proposed district plan will increase costs and create uncertainty, and will restrict rather than improve the current plan. Finally, 2 submitters have raised in their evidence about the limitation of the E-plan and the GIS technologies, particularly concerning how sites of significance to Māori are shown on the planning maps. These matters are subject to submission points that will be considered later in the hearing schedule at either the sites of significance to Māori or in the planning maps hearings. Finally, I wish to correct an error in the general miscellaneous Section 42A report. In Appendix 2, footnote 1 states that Forest and Bird further submitted in opposition to the climate justice full submissions. In fact, Forest and Bird further submitted in full support of the climate justice original submission.
Elizabeth, can we just define that so we can mark our up? So which report was that?
So it's general miscellaneous, and Christine's just bringing around the edit now for you.
Right.
So it's in Appendix 2, and it's one of the tables.
Okay. Elizabeth, we'll get back to you at the end of the session verbally, where you'll give us a summary of your initial thoughts. Of course, the Council 42A officers have a written right of reply generally 10 working days after the conclusion of the hearing, where you'll come back with us in writing. So that will be very helpful as well. Yes, so look, I did have one question just from a structural perspective. The matters that the staff are recommending, or the officers are recommending, be deferred to other hearings. You'll obviously just be keeping a track of that.
Yes.
And report, doing some sort of cross-reference back when you do those reports.
Correct.
Yeah, so there's so much, a lot of paper things, but that's clearly the planner's job to get tabs of all that. So we'll.
We've got a database put in place, spreadsheets where these submissions have been flagged,
Yes.
and also as they come through to the relevant chapter, it comes through, each planner is responsible for making sure that the matters are cross-referenced back, and also it's clear where the deferral came from so that you can track where they are. And then, of course, we will track it with our internal system to make sure that everything has been covered.
Yes. And just one other more general question. In our minute 5, we requested the submitters to track their suggested wordings. It was actually a suggestion to me from Commissioner Mars, because there's sort of 2 sets of changes, or maybe probably more, sort of going through that, where the 42A reporters are recommending some changes, and the submitters will like some changes on top of those. We found those very useful, just to signal that we will need to issue a further minute. We'll do that this week, requesting all the further matters, further hearings coming up. We'll be requesting that from each of the submitters. It's a bit extra work, but I think it does clarify the mind, certainly helps us a lot. So thank you to those that have done that for us. And just one other general question, as there was, while we're sort of fresh, are there any sort of uncertain matters regarding the directions that the panel's given from the council staff point of view at the moment?
Not that I can think of off the top of my head, no.
Yes, yeah, so it's all clear what we're asking for.
Just, I assume you know the district plan much better than I do at the moment, and I haven't really got into the weeds as to how the overlays operate with the exact zonings. It's really just a clear steer, and we'll get down to it. Are there instances where the same activity is dealt with in an overlay as well as in a zone? Are there any of those situations?
There shouldn't be.
Yeah, because that was an issue that, and still does, plagues the Auckland one, which is a much bigger plan with a whole lot of other things, in particular with what was called a special character overlay, which sat as an overlay and had different development controls for buildings for that land that were either more permissive or more restrictive than the development controls that sat in the underlying zoning. And it just created a hell of a confusion. And so I'd be quite keen to see if we can avoid that sort of situation here. And it usually only comes where an activity is either regulated by a rule or standards, both in an underlying zone and in an overlay. So I think we just sort of keep our eyes on that to make sure we don't get into those situations, because it just creates a lot of conflict.
I wonder if I could just ask a supplementary on that. So Commissioner John asked you about whether there was a rule, whether there were rules in both a zone and an overlay related to activity, and the answer is there shouldn't be. What about a district-wide rule and an overlay? So when I'm thinking of earthworks, for example, could there be 2 sets of rules for those?
Yes, there are instances of those. So,
yeah. So there might be a rule on earthworks maximum volume, generally applying to a particular zone,
but it becomes more restrictive
under and so the intent presumably is that the more restrictive rule would apply.
That's right, yes.
I use the word intent.
And that has been highlighted with one particular submitter here, which has got me thinking how we can look to try and avoid those situations as much as possible. So
all together.
Yeah.
There was another very complicating scenario in Auckland, and I don't anticipate will happen here, where council wanted to enable specific activities in specific locations and use the precinct tool.
Yes.
And even though the land still had an underlying zoning, it had a precinct over the top. And then it had a sort of almost like a gate sort of scenario that based on what the outcome was, the precinct either overrode the underlying zone rules or it didn't. And I mean, there are still instances in that plan where you don't actually know which rules you sort of, because an example you might have had in precinct X, we want activity A to be enabled, and so we're going to make it a permitted activity. But in the underlying zone, that activity was discretionary. And how do you deal with that relationship? And so you need some very clear rules of interpretation and application, which I suspect we won't need to get to that level of detail here because the plan that doesn't cover the same degree of resources. But even so, just keep our eyes on that sort of issue.
Would it be fair to say that maybe in terms of those mechanics, just with the questions from Commissioner John and Commissioner McMahon, that ponder those, Ms. Edwards, and when you reply back to us on this chapter, if there's anything that perhaps obviously it sounds like you've double checked through everything probably a number of times, but yeah, just confirming that would be good. Any other questions?
Just a couple of clarifications, really. Just in paragraph 65. This was just in regards to the submission from the Defence Force and whether there'd been any response from them. I haven't seen them come with any evidence. Perhaps we'll pick that up in that chapter.
You're seeking a deferral of the matter.
We'll hear from them if that's no.
Yes. So the hearings administrators, I presume, are just keeping tabs with all these deferrals as well, with notifying people when they're due at different hearings. Yes, so there's a correlation there. Can I wonder, there's people just outside, if someone could poke their head out and welcome them in, because yes. And probably, and I'll probably in the introduction, I'll probably do this each morning. The first hearing, people were sort of coming in to know where to sit, but they were in the corner. So just as we get started to try and draft people into the far corner when we're here early. So look, there are 3 new people that just arrived. So could you just perhaps stand up and just say hello and let us know?
My name is Greg White, representing Ngāti Tama today.
Yeah.
My name is Ashley Gallagher. I'm the district planning on the
Oh, okay.
I tēnā koutou katoa aroha chamberlain every relationship lead for EPTC. Kia ora.
You said you're on maternity leave. You're at work. Well, that is dedication.
Where did
The other clarification, this is at the paragraphs from 75 through to 78, and it's that town settlement, and I was just wondering if you're aware of, is there a New Zealand definition of a town and settlement? I remember there used to be cities, towns and villages one time or another, but is there a more recent definition of those types of things?
Not that I'm aware of, although the National Planning Standard does use some of that language, where they have, for example, I think one of the options is a settlement zone, and this is a brief description of what they consider to be a settlement. And obviously it goes up from there, depending on the size of the actual town, city, metropolitan area. So not that I'm aware of.
I know there's international examples, but in that case, we don't have one city in New Zealand. And then everything else is a town.
Just one, and it's just to echo the chair's comments about tracking those further submissions, and two particular examples that spring to mind. One is in the evidence of Carolyn Ratford, Transcar paragraph 11, just where she makes the point that she acknowledges that the 42A report recommends that this particular issue that she raised about how the plan works be transferred to the network utilities chapter, but then goes on to say that the submission point wasn't specific to the network utilities chapter, so that was a point for the entire plan. I'm sure you're well aware of that, but it was just one that I marked. And similarly in the Heritage New Zealand letter on their second to last paragraph, they They're almost the converse, because they seem to be happy to deal with it just under earthwork subdivision and historic heritage hearings as opposed to the whole chapter. So two sides of the spectrum there.
That's, we'll just happily leave all those suggestions to the plan team and the hearing administrators, and I'm sure that we double checks to make sure no one's forgotten about, and that works out. Certainly, if there's any concerns about orders of hearings, I'll hear from those through the parties and just deal with them one by one if they come in. So thank you very much for the words. Ms. Ritchie, I think you're next.
Yes, good morning, kia ora koutou, and good morning, commissioners. My name is Joe Ritchie. I'm a district planning advisor and district plan team, and I've written the section 42A report for the Part 1 Tangata Whenua section. The Part 1 Tangata Whenua chapter is a standalone chapter required by the National Planning Standards, which requires district plans to include a Tangata Whenua or Mana Whenua chapter in Part 1 introduction and general provisions section of the proposed district plan. The provisions in the chapter must only include context and process related provisions. They don't include objectives, policies, and rules. There were 13 original submissions and 10 further submissions on this chapter, some covering more than one submission point. Only 2 of those were not from iwi and hapu submitters, and those 2 were from Heritage New Zealand, Pauhere Tāna, and Kaingaora. The key issues identified in the chapter were better reflection of tangata whenua engagement as cultural experts in resource management processes, strengthening and clarifying wording in relation to the resource consent notification process for statutory acknowledgements, and addressing some spelling and information errors in relation to iwi and hapu and Treaty and Council arrangements for tangata whenua. The evidence provided on this chapter has indicated that there are some minor spelling and other further clarification changes we could make to the chapter. And the biggest issue relates to the GIS internal viewer conversation. That's it. Thank you.
Thank you. Ms. Ritchie, I do have a couple of questions, but I'll hold those and see what anyone else does. No.
I just had this is going to come up in the submissions. I just wanted a better understanding of the links between this. Sorry, this is just in specifically regards the Treaty 7 interests in the GIS. I just wanted to understand the link between those and the different staff. Like, is it accessible to the planning staff? I'm assuming it is, but you've got this database, you've got the GIS interface.
Yes, yeah, there's a planning tool known as Miles that covers all of the aspects of the council's work that they need to know about, including obviously pipe work and infrastructure and things like that, but it also does include statutory acknowledgement areas.
And how would a planning consent staff member know to check that, or is that just part of the process? The checklist they're going through, that's just...
Yes, it's part of the process. When the application comes in and is anywhere near, obviously, a statutory acknowledgement area.
How would they know it was a statutory acknowledgement area in the first place?
Well, most of them do know it through their work, their ongoing work, but they would need to check the planning maps as part of their approach to the application.
But the planning maps you're mentioning, that's different to the planning maps?
No, I'm meaning, sorry, the internal planning tool.
Okay. And you said most, what about the other ones who aren't in the most? How do they find out?
They would be taught to look on the planning tool in the same way that they have to use the planning tool to check every other aspect of the activity.
And then I think I just had, I just wanted to know why this is going to come up during the hearings where a matter is in one hearing, but you think, geez, shouldn't that have been in another? So that it's a sort of a nuance back. And this is just in regards to these submissions from Ngāhapu or Potapa. They're in the miscellaneous, and it seemed to me that they would fit more comfortably in this particular section. I haven't got any clarifications about what you've actually written, just why it was in that particular one, not in this particular.
It was just because it was coded, because it was relating to the whole plan. It was coded to
Yes,
the.
okay. Yeah, that makes sense. Thank you.
Right, so I just have a very general question, which I'm sure Mr. White and Marco will help me here too. In terms of the option around using the term about mana whenua or tangata whenua, is the preference of iwi and hapu to use tangata whenua in planning instruments? Is that how that's evolved and that choice has been made?
I'll let iwi hapu discuss that with you too, but my understanding is through a discussion with the Ngāti group, it was quite strongly recommended that we use tangata whenua, not mana whenua. But I'll let them respond as well if they would like to.
And when we talk about, quite often we hear people talk about mana whenua hapu, just those terms of arts, which maybe Marco, and when I think you're appearing it later, so maybe just give us, because preferences do vary around the country, I know, between iwi and hapu and how they prefer to be referred in terms of just a general approach. Look, I do have a question about your paragraph 79, Ms. Ritchie. This was touched on in hearing one about given the national planning standards certainly encourage and require a lot of integration and partnership with iwi and hapu groups. So you say there at the moment, under the standard, when you say council must provide summaries, so that's a requirement of the standard?
It's a requirement of the treaty settlement sort of provision for statutory acknowledgement areas.
Okay, so does that occur in each treaty settlement? Or is that just... It
does. There are minor variations, but the general provision is that local government must provide copies of the applications before, if they are in any way associated with statutory acknowledgement areas.
Yes, and as you say, or someone says that a lot of those areas are associated with waterways,
yes,
coastal areas. They're all mapped.
They're not all mapped. There's as I was perhaps going to say later on in response to Mr. Holswich's submission, I don't know if you're aware, but the treaty settlement maps for rivers and streams, especially for some of the later treaty settlements, are only a line on the map, and it says a such and such river and its tributaries. And there was a reason for that, a legal reason for that. And so it's hard to then have a data set, a GIS data set to then map those rivers. And so we haven't opted at the moment to do that.
So you just look at the definition of river and the RMA. Just asking you, how would you, were you not a consent?
No, I'm not.
But if you were thinking about, well, how does a plan respond to the requirement to notify up to an area associated with statutory acknowledgement areas, if that requires some interpretation by the sound of things? So there's various options. You could try and map them, you could agree where they were, but then maybe some thoughts about that.
Yes.
You don't have to reply right now, but even if you thought about that and perhaps come back at the end of the session.
Certainly.
And look, the other thing is there any reason why the council couldn't just provide a public list of all the applications that come in on whether they're notified or not? I know that's what Hawkesbury Regional Council, for example, does, and people can just, because when they're lodged, applications are publicly available. So, on an option basis, various parties could say, okay, well, I'm up to date with what's happening, including where perhaps the council deals with non-notified applications. How would iwi and hapu get any involvement around these things if there's a non-notified process going on?
Yes, because I'm not part of the resource consent team, I don't feel able to totally answer that today, but I could provide a response for you.
Yeah, just sort of information, good information is generally good.
Yes.
In terms of those processes, but yeah, just have a think about that. Perhaps come back. Look, that's me. We're respond to any other questions. Right. It has Mr. McMahon.
Ms. Ritchie, just two clarifications from me on issues 2 and issue 1, starting with issue 2. I'm just interested in the relationship between statutory acknowledgement areas and sites of interest to Maori. Would there be instances where there are sites of interest to Maori that are not part of statutory acknowledgement areas?
Yes.
Okay. And the requirement at the moment is that council must provide summaries of applications for statutory acknowledgement areas, but that may not include all sites of interest to Maori. Yes.
I think if a site of interest, site of significance was within that area, then it would be part of the application.
If it wasn't though.
No, I guess not.
No, and I'm not trying to get into the substantive thing. I'm just trying to understand.
Yeah.
Your paragraph 79 doesn't recommend any change to that, does it?
It doesn't. This was just in response to a request that there'll be a clearer statement of how the council responds to statutory acknowledgement areas, applications.
Right. Yet to hear the evidence from Iwi and Harpu. I just wonder if you could keep a live thought of how the to what extent adding sites of special interest to Maori to the statutory acknowledgements direction might be of assistance in terms of plan direction, given that that second issue was about strengthening and clarifying wording in relation to resource consent notification processes. At the moment, there's obviously a clear focus on statutory acknowledgement areas, but as you've just said, not all statutory acknowledgement areas will include all sites of interest to Maori. If the sites of interest to Maori are met in some way, then that might be a potential solution.
Yes, they are mapped in the district.
Yes,
in the proposed district.
And then just my final clarification was on issue 1 and your paragraph 70. And I'm just taking that that's a soft direction in the plan from council for all parties to act reasonably. There's no absolute direction, is there?
No.
And that's not the intention.
No.
Thank you.
Thank you. Right, I think we're now ready for you, Mr. Johnson. Just come up to the hot seat and make yourself comfortable.
Nothing like going first.
So you provided a statement of evidence, Mr. Johnson.
I do.
Do you have a summary at all? Or it's pretty.
This is different, is it? So what I've provided Christine with is a one-page summary of my evidence. I've also given some examples that I thought might assist the Hearings Commission. And that's what the bulk of the paperwork is. I don't intend to read it.
Thank you.
Good morning, everybody. My evidence for hearing number 2 is relatively brief in recognition of the generally affirmative response to my submission by Ms. Edwards in the section 42A reports, which relate to the general approaches used in the proposed plan. I would note that my submission as a whole predominantly relates to the functionality of the proposed plan from the perspective of a former policy planner currently involved in implementing district plans through consent applications. Accordingly, there's only one matter to which I wish to speak at this hearing. This is in regard to submission points 484.3C, specifically the manner in which the rules are structured and the inclusion of effects standards within the activity lists. This matter is addressed in paragraphs 23 to 27 of my evidence. The rules are designed to give effect to the objectives and policies of the proposed plan, and therefore their content is of key importance. However, I consider it's also important to ensure that the rules are clear and as concise as possible, so as to avoid lengthy debates or challenges as to their interpretation. As stated in my evidence, whilst I agree with Ms. Edwards that the detail of the changes is most appropriately addressed through the section 42A reports for the relevant chapters, I believe the proposed plan would benefit from a top-down direction in regard to the structure of the plan. There are a substantial number of chapters, and I've got my copy of the district plan here, and the need to cross-reference between them. It is for this reason that I requested the hearing panel give consideration to providing such direction. The rules are comprised of 2 parts, the activity type and the effects standards, which I incorrectly refer to in my evidence as performance standards. As noted in my evidence, a number of the chapters include effects standards in the activities section, which is delineated by an R, as well as the standards sections, which is indicated by an S. I have given a number of instances in my evidence where I found this split to be confusing. My suggestion is that all effects standards should be given under the latter part, under the S. I'm aware of the requirements of the National Planning Standards and the electronic nature of the proposed plan. In order to more fully demonstrate the points made above, I've put together some examples as to how chapters could be restructured for subdivision and low density residential zone. These examples do not change the substantive content of the rules, although in some instances I have removed what I consider to be repetitive or redundant content. These have been prepared using a standard word processing program, and I have copied and pasted from the electronic version of the plan. I just made that point because in a Word document, you've got a really bit more functionality potentially than they have under the electronic version of the plan. And also I can't get the same colours. So it will look slightly different. In the examples provided, I have retained the general matters of control, matters to which discretion is restricted in the activity part of the rule, although my preference would be to distribute these to the appropriate effects standards as illustrated in attachment B2. In my opinion, this structure would further ensure these matters are appropriate to the standards being applied, assisting applicants and councils in determining the matters of concern and further simplifying the structure of the plan. However, I recognise that this latter version would require a substantive alteration. I also recognise that other submitters have also made submissions in regard to the structure of the rules. Thank you for your time. So what I have tried to do in the examples that I've provided you with is just demonstrate how what I refer to as the effects standards can be taken out of that first part, the activities lists, and brought into the second part. And as a former policy planner, I find that having all of those in one place actually gives you the opportunity to make sure that there aren't matters of conflict. So the first one that I've given you is for the subdivision chapter. In my evidence, I noted that we had some standards such as minimum lot size under the activities lists. We also had minimum lot sizes under the standards, and you were basically going backwards and forwards between the two to try and work out what actually applied. I've been doing this for nearly 30 years and I found it confusing. So it is of concern that perhaps somebody with a little less planning experience might find it more so. So the examples are intended to be perhaps helpful. It's quite often difficult to explain in an evidence statement how that would actually operate. I also wanted to make sure that it actually could work. So hence the example. So the first one, what I've done is where I've moved things.
So this is attachment A.
This is attachment A, it's for subdivision.
So is this your proposed revision of what's there, or is this
Yes,
what's
it is. No, this is my proposed revision. So what I've done is I've had a look at all of the effect standards that were under the first part, the rules, and where they could be moved into the second part, and in my opinion, make the provisions that are trying to be applied clearer. I apologise for not putting this with my evidence, but we had initially thought that it would be better on a chapter by chapter basis. It was only when I was reading through my evidence that I thought it might help at this hearing. So where I have moved something, I've generally tried to put that text in red, and I've also made a reference to where I've moved it from. So in this particular instance, it reduces the number of activities, because to my mind, the ones that are currently restricted discretionary actually deal with effect standards. That's to do with right of ways and vesting of roads.
Where you've moved something shown in red,
yeah,
is the wording generally retained?
It's generally retained, yes. Like I said, I tried to copy and paste from the website. That didn't always work, so if there is some garble, I apologise.
Was it a difficult exercise doing that for the 2 changes that you've done?
It took me 2 days. Mostly, to be honest, to do with formatting issues. But
Ms.
also
Johnson, yeah, sorry to interrupt, but we've got some new people with us. I wonder whether you could just ease down where you can, particularly the front row, come down a chair or someone.
That's my chair.
Oh, that's your chair.
That's all right. That's all right. There's a double chair over there.
Okay. So, welcome everyone. I'll get you to introduce yourself to Edith Watson's evidence under the system recently. So, thank you. So sorry to interrupt you there. Carry on.
So just to explain what I've done with the subdivision chapter, like I said, where I felt we could take the effect standard out and put them into the actual effects part of it. For the subdivision particularly, as I've said, that makes it a whole heap more clearer in terms of minimum lot size. So in the second one, which I've provided you with, which has 2 little bits that are appended to it, so we're talking attachment B. I wanted to do one for district-wide standards, which is the subdivision chapter. The second one is for zones, to make sure that it actually works for both. And also in the zones, there tend to be a whole lot more types of activities. So
what you've hit upon here is that there's sort of 2 subtly different creatures in the plan. One is the qualifier for you to take advantage of that status. And then you have the standards that apply when you do. And I wonder whether in bringing them all into the things you have to do when you do, you might be missing some of the pre-qualification to be able to rely on that particular status. And that's certainly how I've read the subdivision rules. So you can only rely on the controlled activity status where you've primarily met one of the key criteria, which is the creation of lots don't limit access to existing allotments. So that's a tick. I'm now controlled. And at that point, the standards therefore apply. Is that not how you've seen it, or do you see that that's probably a bit too subtle?
With respect, I think it's probably a bit too subtle. The way that I see it is that you fundamentally have 2 component parts. You are an activity, and under that particular activity, you were talking about components that you have to meet. you equally have to meet the components under the standards. So, for example, with subdivision, as it's structured currently, you've got some minimum lot sizes under the rules. You also have to be able to provide vehicle access. You have to be able to provide water connections, all of those sorts of things. And those are under the second part, or the effects standards of it. All I'm asking you to do is to put those into the same place, so that the first thing is, I'm a subdivision, I'm a boundary activity, therefore I'm controlled. If I meet this next bit. I'm a other type of subdivision, therefore I'm also controlled, except for some reason rural lifestyle. I'm controlled, but I've still got to go through all of those other standards. The way the plan's structured at the moment, you have to do that. Why not put everything in the same place?
No, and I see the logic to it. And it does avoid debates about whether you can actually take advantage of the particular activity status. Because on a lot of those, older plans, you would have almost, subjectively assessed qualifiers as to whether you were discretionary or not. And of course, we sort of can't do that. So, yeah, and just reflecting on other examples where the rule tables and other more modern plans, you will have a whole lot of qualifications and descriptors about your activity that, whether you discharge within 100 metres of the sea, you're a discretionary activity. Then you have another activity which is discharge greater than 100 metres from the sea, you're a non-complying activity. But then you've got a range of standards that apply even beyond that sometimes replicate the same things. So yeah, it's something I think I'll think about. Yeah.
And if I might, I'm very interested in this line of questioning, because under section 32, we've got to decide what's the most effective and efficient way of producing these. I just wondered whether, I understand the desire to keep all the standards in one place and not have them in rules and then effect standards and potential duplication, potential conflict. How would you feel about having the matters over which control is reserved switch to the back and have the rules and standards at the front? So to take Mr. Littlejohn's point, you know immediately whether you actually qualify for that particular activity status, because you're a controlled activity if you meet standard X, Y, and Z, and because you don't, the matters of control, the matters of which control is reserved, or the matters of which discretion is restricted to, don't come into play really until you've locked in that activity status. So my question is, how would you feel about reversing the order, keeping the groupings that you've identified, but reversing so that the activity status and rules are up front, standards are up front, the matters of control at the back?
The national policy statement says that the matters of control should sit with the status of the application, which is an interesting thing, because when you look at the rules, you've got two component parts. So I guess which part do they sit with?
Putting the national policy statement to one side, the national planning standards to one side, from a practicality point of view.
I guess.
Because what Commissioner Littlejohn seems to make an important point, that there's a bit of redundancy looking at the matters of control if you don't actually trigger that activity status and you're actually a discretionary activity. So wouldn't the plan reader want to know what activity status they've actually triggered before they actually work out what the matters of control or matters of discretion are?
I agree that you want to know what your activity status is.
Yes.
But I'm thinking of, for example, permitted activities. So in the zone chapters, you have a whole heap of permitted activities. You still need to go to the standards to work out whether you're permitted still or not.
But in your example, it's not until page 1, 2, 3, 4, or 4 or 5 that you get to know what the first relevant standard is. You've got to actually delve your way through the matters of control or discretion first.
My preference is to actually, and I've illustrated it in the very last attachment, which is B2, is to actually just have a list of activities, because looking at it from a practitioner's perspective, what you generally know is what you're going to be doing. So the first thing you want to know is, well, am I potentially permitted? So for example, in residential zones, residential activities are permitted. So, yay, I'm permitted. I can now go and have a look at the nitty gritty of it. And the nitty gritty is the standards. How high can I go? How much coverage can I do? All of those sorts of things. So,
but what if you're only permitted if you meet those standards?
Well, that is the nature of it.
Do you
are a
put a-
two-step thing.
But do you then put a provision in here which has another rule which says residential activities that are not permitted are restricted discretionary? Do you sort of provide the default situation for status in this table?
I don't think you need to. It's inherent if you don't. It's inherent that you have an activity status and you have an effect status. You need to be permitted under both. So you could be a permitted activity as a residential activity. You then go to the rules that if you're over 8 metres in height, you're no longer permitted. And that's the way the plan's structured at the moment. It comes into functionality, usability.
Well, yeah, I don't think there's a right answer here. All plans do it differently. I mean, Under A, for example, has the you are a permitted activity if, and then it's this massive list of everything you have to tick off before you can get to the end and go, phew, I'm permitted. If you breach one of them, then there's another little column which says, if you don't meet one of the standards, you are this, and these are your restricted discretionary matters sort of thing. So, and I concede trying to peel this orange in a way that is the most user friendly is a challenge, and there are different views on it. So, I mean, I appreciate you thinking about it.
I mean, for me, the main issue is that the way that it's structured at the moment, and as I understand it, and Ms. Edwards may want to clarify if I'm not, is that where you have something that's specific to that particular activity, then that's where they sit in that rules chapter. My issue is that at the moment, doing that is really confusing. And so if you pull all of the effect standards into the same place, you lessen the potential for contradiction, you lessen the potential for confusion. Hopefully, it works better. So in the first, in attachment A, I've given you one which most closely aligns with the structure of the plan as it is currently. And then with the attachment B, I've given you a couple more options going further and further away from that current structure, which I recognise may potentially not be workable with their electronic format, or may require an awful lot of work on the planner's part to actually restructure it that way. So if we just have a look at attachment B, which relates to the zoning, the first one is closest to the structure. The second one is where, so for the first one, for the residential zone, all I did was I pulled those standards pretty much as they appear and pulled them into the second part of the chapter. In the second one, what I did was I actually changed it around from an activities-based set of standards. So for example, you have currently got standards for, so for example, at the moment, you've currently got some standards that I've pulled out of the rules part of it for boarding houses, home businesses, residential visitor.
Ms. Johnson, can you just hold, has Ms. Macbeth got her speaker on? Can we turn that off? Thank you. Carry on.
Slightly disconcerting.
Yes.
So I've just, in the first one, I've just pulled them over under the activities that they were. And the second one, which is attachment B1, what I've tried to do is pull out the parameter, if you like. So for example, a number of the parameters under those activity headings relate to the number of persons accommodated. A number of them relate to vehicle movements. To a certain extent, this reflects an effects-based structure, if you like. It's talking about what are we trying to control and why are we trying to control it. So for example, for vehicle movements, home businesses, residential visitor accommodation and supported residential care all control vehicle movements. They all control it to the same extent. Is there a reason for that? And if so, if you're exceeding them, what are we concerned about? And that's what amalgamating those standards by type enables a comparison to be made. So that's sort of like my intermediary version, and then I've got another one. I did question whether I should sort of like give you part 2 and part 3. But I thought, well, if I'm trying to make a point about functionality of the plan and also making sure that you're actually applying the rules where you want to apply them. Do you want to apply vehicle standards to other types of activities where you've got differences in the standards that you're applying, for example, gross floor area? Why have you applied one particular standard to one type of activity and a different standard to another? It just enables those questions to be asked and for you to make sure that you actually understand what you're trying to get at.
Okay, Ms. Johnson, I think I'm clear what you're looking at. And certainly as an experienced practitioner working on the plan, assisting the panel, you've certainly gone to some lengths to provide actual examples. The only comment I made is that we'll hear from Ms. Edwards on these just briefly by the end of the day, and certainly the opportunity to have a good think about this is quite important. Are you all within scope in terms of what you're suggesting, Ms. Johnson?
My initial, are you asking about the examples I provided?
No, the examples with your original submission. Are you happily within the scope?
My scope was that I thought that the way that the rules were structured is inappropriate and that the standards should be grouped. So I believe that I'm within scope.
Okay. That's fine. I just have a couple of other sort of more general. Generally, the readability of the plan, just the way it's available on the plan, everything else, is an improvement from the last operative plan in terms of readability, or because I've tried to read the operative plan a number of times and scratch my head. Just your general feel of the accessibility of the plan for staff and people to understand.
You realise I was one of the members of the team that wrote that plan.
I don't realise that.
You do now.
So I'm in a wee bit of a tricky situation here. Obviously, I feel that the plan that, I mean, they're slightly different in that the existing plan is purely effects-based. So there are no activities lists. It's essentially the second part of the rule.
Yes.
And I had an awful lot to do with the structure of the plan. And I felt
proposed
that quite,
plan.
No, the operative plan. The operative plan. So I felt it actually worked quite well. You might like to ask some of the other practitioners here how they felt about it.
I certainly, well, I've used it quite a bit. So yes. So look, the other thing is in terms of the consultation processes. When did you actually leave the council, Ms. Johnson?
2003.
Okay, so you've been a consultant for a while. You've been following the proposed district plan as a local practitioner during this evolution?
Yes, I think so.
And the consultation processes generally, ability to comment, draft plan, what's your view on those?
I think the council put an awful lot of effort into the initial meetings and trying to involve people. And having been through that process myself, I know that it's quite difficult with a plan as opposed to a variation because it's so large. The only thing I would say is that there was a whole lot more detail in the proposed plan than there was in the draft plan.
As you'd expect, perhaps.
Which makes it a bit tricky in terms of the ability to reread the entire thing within the timeframes that we're allowed.
Okay. Thank you for that. Do you have any more questions?
The areas of attention, and you've just focused on one of them today.
That's correct.
Interestingly, the 6 major areas in the Edwards identified as that are still under attention. Do you think these issues are particular issues for E-plans? Or are they issues for the old operating plan? So.
In terms of, because I printed out the district plan because I can't watch on my computer, if this was even just a paper plan, the issues that I have with the structure of the plan are still there. And to a certain extent, a lot of them come from the national planning standards.
Yes. And thank you for that. Some of the rules in the proposed plan have legal effect already. Most of them. Have you, as a practitioner, had any cause to deal with applications that trigger those rules that are currently have legal effect?
I think I've done one.
And how did you find that exercise? I mean, in terms of the themes that you were raising today.
It was a relatively easy application, in that although the rule applied, it didn't trigger any particular consideration in terms of the consent application.
Just out of interest, what was the what body rule? Yes. That's all for me. Thank you.
Other commissioners?
Yeah, I think that's very helpful. One of your points, paragraph 24 of your evidence you filed, and then you repeated it again in paragraph 4, is requested that there be some direction given by the panel. We have indicated we might give some interim guidance, given that this rule structure would be of, I guess, have ramifications right down through the plan in terms of how people present evidence to us and format what they see. Do you think that this is a matter that interim guidance would be helpful on going ahead?
Yes.
Okay, all right, thank you.
Thank you, Ms. Johnson, and thank you for your time. Will we see you again in other hearings? Okay, look forward to that. I'm sure Commissioner John will have a lot of questions on the detail.
Well, not the planning yet.
Oh, well, maybe you're legal. Yeah. Well, I think we will carry on. Mr. Dickey, please. And while you get yourself settled, I think 3 or 4 new people have come into the hearings, and we've done some general introductions. So let's stand up and give your name and your affiliation.
My name is Howie Carmody. I am a member of, a board member of Te Aotearoa, the Tainga or Te Aotearoa. Also co-chair of the Wellington Matua Council
Thank you, Carmody. Good.
We are my colleague, Mr. Russell Gibbs, Marie Gibbs. My name is Hakuana White, and greetings to you.
Mr. Dickey. Thank you.
Thank you. Morning, commissioners, and the opportunity to be here this morning. Also, like to say thanks for all the fellow surveyors to coming along and support. I am a survey manager at Landpro, and have been consulting surveyor based in New Plymouth since 2005. I'm the current chairman of the Taranaki branch of the Survey and Spatial New Zealand, previously known as the Institute of Surveyors, and have been a member since 1998. A little bit of background, surveyors have been at the forefront of land development in New Zealand for over 150 years. Our members are professionals in land development,
urban design, resource management, civil engineering, positioning measurement, cadastral surveying, hydrographic surveying, and many other roles in the spatial sector. We are the one profession that specialises in the entire land development process from start to finish. We are the ones left to explain the subdivision and resource consent process to clients wanting a clear and concise direction on their projects. For example, if you inquire at the council for any sort of subdivision, their answer is to contact a surveyor. With respect to our submission, the Taranaki branch opposed the proposed district plan in its entirety because members cannot see how the proposed district plan in its current form will benefit the region, community, business owners and ratepayers. It's acknowledged that initial consultation was undertaken in the branch with the branch and that workshops and meetings were attended by members. However, the consultation mainly focused on the strategic direction and overarching policies rather than the rules. Consultation had a token or tick the box feel to it. And there is a big difference between consultation and meaningful consultation. The consultation did not go into any detail on the proposed new rules. The rules provide the biggest surprises with many unexpected changes and additional rules. In our opinion, it would have been far more beneficial to include these rules during the consultation, which would have provided valuable feedback to council and no doubt would have reduced the number of submissions and the length, and the length of time taken for these hearings. The length of time allotted for submissions, maybe 20 working days, was not sufficient time for working professionals to review all relevant parts of the district plan. Members have spent many hours reviewing the plan and have not come close to covering everything within the timeframe allotted for submissions. The resultant online proposed plan, whilst colourful, is difficult to use due to its size, complexity, and general readability, and relies on the exceptional online connectivity to even have a chance to navigate it efficiently. It is clear from the current content that has been able to be canvassed that the plan will increase processing times and costs for all involved, that is clients, professionals, and council. Members are frustrated with the current direction of the proposed district plan, with more policies and rules adding to the complexity and uncertainty of the proposed district plan. This approach will see a significant impact on the region to develop in a sustainable and cost-effective manner. It will result in more expensive housing as applicants recoup the increase in costs. It will hinder business investment in the district when other districts are providing more convivial environments to locate. In summary, our members oppose the entire plan and request that, number one, further detailed consultation be undertaken to reduce the levels of uncertainty and costs to ensure that when implemented, the proposed district plan will benefit the region. And number two, to be heard at further hearings involving parts 2, 3, and 4 of the proposed district plan.
Thank you, Mr. Dickey. I have 2 or 3 general questions to kick off with.
Yep.
Your paragraph 15 of your summary, are you saying to us that the draft of the plan did not include rules?
I think in terms of the draft, from myself, I wasn't aware of any of the rules, specific rules, until it was, the plan came out.
Are you aware that the council did issue a draft district plan for consultation?
Yeah, I'm going back on the process. I think we were. Yeah.
Yes. Okay. Yeah. And are you by my reading of 15, you're suggesting that draft plan didn't have any rules at all. Is that what you're saying, or?
Well, I think obviously it probably did.
Okay, and did the Institute of Surveyors and other surveyors make comments and suggestions on the draft plan at the time? It was a non-statutory process that councils usually use. Been involved with a plan where they didn't do that, and it was pretty awkward, but
I'm not aware of the branch making any like submissions or comments on it.
did any of your members that maybe are here today help us?
Yeah, I think the draft plan did have rules in it, but it was my understanding from what we've been given that these were at a formative stage. So,
Yes.
so I'm not sure if people had the time to even read up the new plan rules when they're working still with the old plan.
Sure.
So I think that there were rules there, but to be fair, I don't think they were specifically to our attention, or the degree of change.
Okay. All right, my second question is, you're aware, Mr. Dickey, of the National Planning Standard?
Yep, in terms of.
Yes.
Yep.
Yes. And are you aware that that requires councils to formulate their plans in a very specific format and way?
Yeah.
Yes.
Yeah. So consultation and that was undertaken. Yeah.
Okay, but no, that was my question. But are you aware that New Plymouth District Council's plan has to be formatted and structured, organised in a way to meet the National Planning Standards? Yes. Okay. And are you also aware that the council has to do a Section 32 analysis which looks at the efficiency and effectiveness of the plan provisions as they're notified? Yeah, and has your, I'm just thinking back to your submission itself, does it actually propose anything different in terms of outcomes?
We haven't, the submission hasn't proposed anything like in particular. It's just really the desire to be heard
yes.
and have more time to understand the rules in terms of and provide some feedback.
Okay, but you haven't actually included any suggested wording. You're just saying go back to the drawing board and start again and consult with us again. That's
the general feeling from the members. Yeah.
Okay, thank you.
I think you've just asked one of my questions about whether you were going to come back to us with any particular changes that you were requesting. I'm just looking at 18 and just talking about the complexity and the general readability. Did you have any particular examples of what you were looking for would be helpful?
I don't have any particular examples, but we could certainly come back with some if that would be helpful.
Because I think the first part is you've identified there's an issue with its readability and usability from your perspective. But on the other side, or if you could say what could be changed or linked to make it more usable and readable.
Yeah, well, I think in where that was coming from was just the amount of times that you need to cross-reference with other parts of the plan.
Okay.
You know, for Joe Blogs, it would be very difficult to navigate. Imagine and get the entire picture without knowing, you know, the whole knowing the whole picture.
Good. Really just interested in the same theme, really. And I guess my first comment is that I'm really appreciative that the surveyors have come along, because for the longest time when I started practicing, I used to think that lawyers and planners knew all about everything. And it wasn't until I realised that surveyors actually know what's actually going on that I realised how much knowledge they do actually have. And so it's really interesting. I enjoy talking to Mr. Sol shortly about that. I mean, this is an evolving space, isn't it? I mean, just as surveyors have had to evolve out of a very hand-drawn situation and to do your work into a very big online cadastral data set. And, we've all evolved into that space, and some would say that where district plans are evolving to is only really just catching up to where the rest of the world is moving in terms of cross-referenced complex documents. When you look back to some of the old district plans where you get to Rule X and it would say refer to Ordinance 27.9.5, and then you'd have to go and get volume 5 and pull that off the shelf, and then that would require you to dig out another volume. And at least when you move into an electronic space, you can sort of click around it a lot quicker if you've got if you understand how that system works. So I think there's a lot of education that needs to sort of come there.
Yeah.
One aspect of your evidence I was particularly interested in is you say in paragraph 21, it's clear from the current content that has been able to canvass the plan will increase processing times and costs for all involved. And I'm just interested, can you throw us an example of that?
Yeah, an example would be we've just been going through a minor boundary adjustment in a rural zone, and it's pretty much almost fallen over because it's had a significant water body within the balance, and the amount of consultation and additional work that's gone into that, the client is pretty much it's not.
But is that a consequence of the structure of the plan, or the fact that there's a resource there that needs to be managed?
Yeah. Probably the resource in terms of the waterway. But in terms of a minor boundary adjustment where you're moving a boundary, say 10 metres, that additional, and aside to it is that it was an ex-forestry block, and the waterways need to be fenced and planted under the obviously statement for water and forestry as well. But of course it triggers additional consultation and everything, the significant water body. And all those factors have led to increased costs and timing to just put pressure on whether it's actually worth the client to move that boundary.
Are you going to come and talk to us about those specific rules in the plan and how they interrelate with those different layers to sort of point out to us where those sorts of resource management issues might not be warranted that much attention if it's a relatively minor position from a subdivision point of view? Are you going to come and give us some evidence about that?
Yeah, what if we looked at it in the parts 2, 3, and 4?
Yeah. Well, I mean,
I'm thinking about the subdivision chapter. One of the issues we have, and certainly with your broad submission, certainly I know the council team will be having, is because it's we don't like it, chuck it away, start it again submission.
Yeah.
I'm not sure that you have scope to be coming to us to talk about specific improvements, and we'd have to provide leave, or you'd have to request, because sometimes people make submissions to plan like that and then just think it's so slow to come along later in the hearing and just catch up. And I'll probably talk to the commissioners at the break about sort of that whole issue of scope to contribute when you haven't asked for something specific, because as an initial submitter, if you had asked for some wording changes, other people that might either support that or oppose that didn't get the opportunity to lodge further submissions supporting or opposing. So like Commissioner Littlejohn, I think the survey profession has a huge amount to offer in terms of workable plans, particularly when we're down the detail of subdivision and development. And I'm wondering, well, I think we'll have a chat about that in morning tea, and come back, because there's a clear sort of fairness, natural justice issue about how the surveyors could perhaps contribute or have the opportunity to contribute, given that you haven't requested any specific relief on areas of the plan that you're probably concerned about. So I think I'll finish other questions, and then looking at the clock, we'll probably have a break, but Mr. McMahon?
Yes, I was going to ask because I wasn't too certain whether the Institute's submission had actually suggested changes to activity statuses, minimum allotment sizes, and questions from the chair would indicate that they haven't.
None in particular from the.
Okay. Yeah, that's going to be an interesting conversation. Just generally, I just had a fascination. When was the name of the institute changed to Zero Information New Zealand?
I think it was
more recent.
Yeah, it was within the last 5 years.
It's interesting, the acronym was SAS. So.
Yes. And I see we both studied at the University of Otago, but I was there last century. I imagine you were there more recently.
It's 98, I think.
So just out of respect for everyone, we will take a break. It's 10:30. We are finding that perhaps it's not in the time schedule. So we will head on order, and if you can have a break, cup of tea, we'll come back at 11:45 and just proceed on. Thank you very much.
I've got some speaking notes, but they don't really reflect. They're more examples, but my name's Pat Sol. I'm a licensed cadastral surveyor. In speaking to my submission, I understand that it can be taken as read, and I don't propose to repeat it here. However, I would like to demonstrate some aspects of my concerns by way of example. There are new rules applying to subdivision of land which contain or adjoin water bodies. So I'm quite pleased to hear some of the previous speakers, because this is a particular issue for us currently, because these rules have legal effect now. So we're working under these rules now. The rules require the creation of esplanade strips or reserves along significant water bodies and along all water bodies on lots under 4 hectares on subdivision. So Taranaki is covered with rivers and streams, and it's unusual for rural land and even some urban land to not adjoin or have within it a water body. These rules therefore have significant impact. I am unsure of the process used to identify what are now known as significant water bodies, but it does include a large number of additional water bodies from that which the operative plan identified, which were then known as priority water bodies. The proposed plan also identifies spatially a large number of other water bodies, but not all. I've recently done a subdivision in a remote location, about 30 kilometres out the back of Inglewood, which is hill country, where a significant water body was shown, and where council's own landscape consultant recommended no strip be created. Yet the consent was issued requiring a strip at considerable cost, presumably because of this rule. For much of its 1.2 kilometre length, the waterway was probably about this wide. On another recent occasion, a subdivision in urban Waitra included a significant water body. For most of its length, there is no longer any evidence on the ground of where the stream was, and it has been successively drained by council's pipe stormwater system through adjoining roads. It's not possible to set off esplanade strips or esplanade reserves where there is no stream or you don't have a bank. It seems convenient that council should require esplanade strips on all water bodies on lots under 4 hectares, when this is the threshold under the RMA when compensation is not required. So this seems to be irrespective of whether the particular stream or drain has any landscape or other values requiring such protection or public access. I'm also aware of other recent occasions where council has required esplanade strips on streams of under 3 metres width. This would appear to be outside the scope of the RMA, and therefore the
the compensation regime apply. So this example is intended to demonstrate that the rule does not appear to have been ground truthed before implementation. Either the rule itself or the spatial depiction of significant or other water bodies requiring esplanade strips is not clear in many occasions. It also makes meaningful advice to clients particularly difficult when their questions, can I do this? What am I required to undertake? How long will it take? How much will it cost? Can't be answered. So in combination with other overlays about water bodies like the National Freshwater Initiatives and statutory acknowledgements to iwi, and combined with other proposed planned rules, the path is extremely complex and muddy, even for the simplest of consent applications. I've heard both my clients and other surveyors talking of how frustrated they are, how the rule is ad hoc and not proportionate, and that the process can be impenetrable and intimidating. This plan does not simplify, it complicates. But more than that, there is so much uncertainty when entering the process that many projects do not get off the ground or are abandoned when timeframes and costs become apparent. This makes it difficult to bring land at reasonable cost to the market. I just want to turn my attention briefly to consultation. What matters most to surveyors and the public is the detail of the plan and how the plan directly affects them and their proposals. I believe council have done an extremely poor job in communicating that detail. If I could refer to a recent example by the Ministry for the Environment, which doesn't even have an office in New Plymouth. In releasing their freshwater proposals, they released the detail of their intentions. That is, how wide a river had to be and the fencing requirements in proximity to that river. And at a New Plymouth meeting, they had several hundred people attended, and some would argue it's a bit of a bun fight, but as a result of these meetings, those initial proposals were modified, and it was actually meaningful consultation. How difficult would it have been for council to have released the detail of their plan by perhaps regular small items or sound bites in appropriate media? For example, do you know that you need a consent to build a deck within 5 metres of your neighbour? Or council want your feedback on whether they should control the position of garages relative to the front of your house or a street boundary. As it stands, the public are largely in the dark about the contents of the plan and have virtually no influence or opportunity to contribute. So I'd be happy to try and answer any questions you may have. But I guess in terms of relief and following on from the previous speaker, I guess what I would like to see, and I suspect other surveyors would like to see, would be some sort of workshopping with surveyors about going through all of the rules, the reasons for them, and perhaps by the Section 42 analysis, having some input into the plan in that way, because I think to leave submissions to surveyors for the next 9 months is pretty unreasonable. I actually think that I mean, I know survey firms and I have picked up on particular rules, but I haven't, for example, submitted on this water body rule. So I know stuff's going to fall through the cracks if we don't do something like that. And that's the relief that I can see that would be available. And that will clearly have to be done quite soon.
Thank you for your evidence and just taking the time to write your statement and also summarise it. It's very much appreciated, Mr. Sol. I'm aware that district planning is complex. I've echoed Commissioner Littlejohn's own experience when it comes to detail. You know, your profession, both particularly spatially now with the tools that you hold, and also your experience and information is hugely important for effective district planning. I'll ask you the same questions that I did ask Mr. Dickey. So when you look back at the genesis of this plan, I think the council planners have been working on this for 3-4+ years. When the draft district plan was released, that was done on the basis of my reading that it was non-statutory, there was a change in emphasis, and it did include rules. Did your other surveys actually participate in discussions with the council about that, or made submissions or comments, or was there any, like I know you're complaining about the councils not consulting with you, but did you make any efforts to basically get organised and talk to the council yourselves?
Yeah, I think there's a number of things that you bring up. I think the genesis was that we had a workshop that Sarah, I think, ran it about the draft spatial plan, and the essence of that workshop, or what I took from it, and what I think a lot of other surveyors took from it, was that this was an introduction around a new concept, a new spatial plan, which I think is a great thing, and I think it's a good thing going forward. But I don't think there was any, the rules were encrypted in that, and I think Sarah probably showed us how to get to those rules. But you've got to realise that as working professionals, we've got locally 3 district plans plus a regional plan. We've got new survey regulations, we've got clients and staff, and all of those other demands. So whilst I think probably some of us came across some of these rules before the notification, there's also an element where that doesn't get around all of the surveyors, and as for a combined response, that didn't happen, probably due to pressures. And that's not an excuse, I know, but some of us put a lot of time into this sort of stuff, and we don't get paid for it. But my concern really is that the nature of the change has been quite dramatic from the existing plan in terms of rules, and there's also been this, and it's not the district planning team's fault, but there's now all these overlays through treaty settlement and through national directives on all sorts of things, which really mean that the plan now is almost out of date before we start. So it would be really good to be able to workshop some of those issues with council planners, so that we can actually get something that's more up to date coming out the other end.
Yes, look, as I said to Mr. Dickey, we're now into a full legal process.
I know.
And as a panel, we have obligations to follow through the hearings and make these recommendations on specific submissions. And we do not have the opportunity to have a process where you might workshop with the council planners and then you look at some detailed wording, and you come back to us and say, hey, let's try this. The process is quite clear. As explained to Mr. Dickey, that submissions need to be clear on their relief. They go out amongst all of the Plymouth district people, and people that might say that's a great idea can say, yes, I support that, and be heard, or I don't like that, or I've quite the opposite view, and be heard. So I'm not sure whether any of the surveying companies have got specific requests.
I know they have.
They have.
And I have other, albeit
Yes.
too, but
have you got specific reliefs to just specific wording changes?
Well, I'm not sure about that, but certainly in terms of rules,
okay. So we'll hear from you where you've got scope on the specifics. We certainly can't require and won't require a stop of the process and a re-workshopping with the council planners. That's just not in our powers to achieve. So we won't be able to do that. The other thing, just a suggestion, if you have clients that have submissions on some of these rules, they can certainly engage surveyors as expert witnesses. And I know some of you have planners in your companies, so perhaps talking with the planning people and seeing what opportunity there are to be involved as plan proceeds as a professional group would certainly be helpful to us, but it needs to be in the scope of either something that surveying companies ask for specifically, or whether a client that you might think about representing as an expert, because we certainly do want to make the plan as effective and efficient as possible, and we'll be doing that generally in the scope of our role, but always assistance from professionals is helpful. So look, I do have a question, and we should perhaps note it for when you reply, Ms. Edwards, about the genesis of the significant water bodies, how they were identified in the process. So we'll just hold that until you report back and to us on that. So I'll hand over, apart from those general comments, I'll hand over to the other commissioners for any questions.
I just had a consequential, perhaps just a notice rather than a question, but just noting on 11th, 13th of October, that's when we're coming back for the hearing on the regards to freshwater and those water bodies, and that's the matter that's raised in your submission today around those, particularly where the significant water bodies have come from. So the questions I have will probably be best posed if yourself.
And I don't think I've even submitted on that, and I'm not sure if any other surveyors have.
And have a good look, as I mentioned, the council website, I'm finding it very helpful, and the cross-referencing and checking, and certainly check in for your members if there's any questions with Ms. Straka and the team to follow it through. So yeah, certainly a chat with the hearing administrators team from the surveyors might just assist any navigation of information going forward.
And just the other one was just in regards to paragraph 22 of your original evidence you sent to us. It's just the statement that there's considerable uncertainty in every process when applying for discretionary non-compliant consent. I was thinking about that in two ways. One is there may be uncertainty about what's the pathway to getting consent, or the second part is that the tests may be, from your perspective, from client's perspective, much higher than they were previously. So it would be interesting to hear more about that.
Yeah, I think the uncertainty is often about the process. Yeah. And when people come to you looking for professional advice, and you look back at them and say, well, I don't know. And that's quite a difficult position to be in, because until we get well into the process, sometimes that's not apparent. And that's often when people have spent a lot of money already. And so you take the rap for that professionally a bit.
Okay, good. That's all that.
Yeah, I blame the law personally.
Well, I think don't get me started.
Well, I mean, in the old days, you had a traffic light sort of system. You know, it was either green or it was red, and the amounts of oranges were very, very small in terms of, you know, the conditional use sort of thing. And then the RMA brought in a much more variegated allocation of discretion, and it's the discretion that creates the uncertainty. And you know, if I had $1 for every surveyor or planner who came and said, why don't you just make everything permitted or controlled, you know, I wouldn't, you know, I'd be retired. But because that gets rid of all discretion and makes the world very, very clear. But the flip side of it is that structuring a plan that way means you can't adequately manage resources in unique situations as they come to you. So it's about finding that spot in the middle in reality. I'm just interested in if you knew of the council's obligations in terms of section 86B of the Resource Management Act,
which say,
well, I mean, it comes back to this position that the date the proposed plan was notified, certain rules had to have legal effect. So to some extent, the council have, you know, had their arm up their back by the law to some extent. Again, I blame the law, which said that where a rule protects or relates to water, then it had to have immediate legal effect. So those rules didn't even have a chance to be tested through this process before they went in there. So, but of course they can change as a consequence of this process. And I mean, I'm a little bit disappointed here that the surveyors haven't sought to get into that a little bit more, and I'm hoping that you do find a way to give us some useful advice.
Yeah, well, that would be good if we could have that. But I guess my concern for the process is that it it's quite intimidating for the public at large and for a lot of people to attend hearings such as this. It requires a lot of work when a lot of that workshop could have been early on, and that opportunity didn't seem to have appeared. And I guess there could be criticism of surveyors for not preempting that, but the reality is that we don't work with this district plan only. We work with a whole lot of other legislation as well. And so time is of the essence. And to get really good, meaningful feedback from either surveyors or the public, you've actually got to put stuff out there that people are interested in. And that's where the consultation, in my view, has fallen down in this process. And it should have happened before we get to this hearing situation.
Yeah, I mean, it's a constant source of amazement to me that people don't find district plans really interesting and want to get involved in them. But I take your point. Yeah, you've got to be working amongst it.
The reality is much more national legislation.
I do hope there was a joke, Commissioner.
You should know me by now, Mr. Chair. One of the things I was particularly interested in your evidence. And it follows on from the hearings we had here a couple of weeks ago about the direction of the district in terms of accommodating future growth and finding a balance between new greenfields rezonings and infill. And the council's taken an approach of identifying some key growth areas, but then also trying to encourage infill. And we had Kama Ora speak to us about how that needs to be. We've got to try and force as much incentive for growth within the city. And so I was very interested in paragraphs 23 through 25 of your evidence, where you and surveyors at the coalface advising people on infill subdivisions are saying that the tweaks that are proposed to the minimum lot size are not really going to make much difference. So that, I mean, and to some extent, that's a really critical issue in terms of being able to achieve an incentivisation for infill over greenfields. I mean, could you give us an example of why you don't think these revised residential sizes are going to work?
Well, I think something to do with zoning. We have some, I think it's called multi-res. Is that right?
Medium density.
Medium density, some new medium density zoning, which is great. But in the process, we've also lost some of what was residential B, which sort of equates to medium res. And so we've got some more, but we've dropped some as well. I don't know that that's a great idea. But in terms of infill, it's all very well to make, for example, subdivision section sizes smaller. But if you retain density at 40%, then you 40% of 1,000 square metres, whether it's one model or two,
it's a big home.
It's exactly the same. So, and then when you meet side yards and building envelope requirements as well, then you're really actually reducing density the more lots you have. So my view is that whilst this plan talks about encouraging infill, the rules don't reflect that, and that the only way to infill and make it more dense is to go up, which is super expensive, more expensive, and
or increase your building coverage.
Yes, exactly. So in combination, the rules don't encourage it, and the zoning as well. And the other part of that is that to encourage infill and reduce, for example, in residential zoning, the current rule is 450 minimum square metres per lot as a minimum. The intention is to go to 400, and whilst that might capture, in my view, from a practical perspective, a very small number of additional lots, that on its own, when you take into account servicing and topography and position of existing buildings, will not really encourage a great amount of infill in that zone. So there are parts of the district, Inglewood and Whitetrail, for example, that have quite a lot of old quarter acre sections, where that might have some effect, but I don't believe that the theoretical analysis that's been given equates to the practical application of it.
In the subdivisions that you're doing at the moment, what are the triggers that make the application harder from a consenting point of view? I mean, I'm talking sort of development standards and those sorts of things.
Yeah, I think there's a great number. But there's obviously engineering standards, and infill, in my view, always requires the same standard as greenfields engineering standards, and in some cases that makes it difficult for development. For example, where you have water services, and you might have an existing water pipe to an existing house, which if it was a metre to the left would be adequate, but because it's in the position that it is, needs to be relayed a metre to the left. And some, I've been told to get rid of, for example, double vehicle crossings, to put in single vehicle crossings. And so engineering standards is one of the restraints.
What happens if you want to not comply with an engineering standard and put an alternative solution up? Does that trigger you into non-complying in the council?
I'm to be perfectly honest, I'm not sure, but council are not endeared to changing the rules in terms of engineering.
The rules are the rules.
My comment. Just getting back to your original question, what prevents that sort of infill development? I think there's a lot of, for example, cross-lease, existing cross-lease properties, which could be turned over to fee simple, where in combination with the engineering and planning rules, it makes it really difficult. But I think to do that is a good thing for the community and for landowners. Yeah, there's probably
it's a good question. What percentage of titles that you deal with would be composite cross-lease versus fee simple?
They're very prevalent from the 70s through to about the late 90s, 2000. So there's probably 50% of development in that time was cross-lease. Yeah. That'd be a reasonable sort of number. Yeah. Okay. So there's a big chunk of them in that period. Yeah.
If you wanted two cross-lease owners wanted to get together in freehold, would their on-site development be assessed against the current standards and require land use consent for breaches of side yards and all those sorts of things? Or
I would presume so.
Any other matters that sort of make infill really hard in terms of the rule structure, the processing?
Yeah, look, just off the top of my head, I can't think of it, but there probably are issues within the plan that make it quite difficult.
Okay, all right.
And certainly the new plan will be more difficult because we have not only do we have yards and building envelopes, but we have proximity of decks to boundary, for example, spacing between habitable buildings.
So we'll have to go through all of those.
So it's in combination with all those new rules that it's going to make it certainly won't make it easier.
Okay. All right, thank you, Mr. Sells.
Yeah, so I won't keep you too long. I don't want to get too much into the detail because that's for another day, but I'm really interested in the conversation that you're having with Commissioner Littlejohn, and your paragraphs 19 to 25 and your original evidence struck a chord with me. And I questioned that you, so once you've talked about minimum lot sizes, building envelope density, talked about the spatial extent of the new medium density residential zone, and all those things. But my question is, have you led any submissions on those and sought changes to those rules?
I've sought changes or put submissions in on some of them.
Yes.
I know other survey firms have put submissions in on some of them, but comprehensively, I don't think we have put in any combined survey submissions. And my concern is that for that reason, a lot of I'm learning new rules every day, as you probably will. But my concern is that a lot of the stuff will fall through the cracks if it's not looked at in close detail. And I don't know whether this process will do that.
Yes, you said that putting aside the rules, you said you were in favour of rezoning larger areas to the medium density residential, but I'm guessing that you haven't lodged a submission to that extent. You haven't identified any new areas.
I think I have.
You have. Okay. So that will be for a rezoning issue later on in the process. Okay. Okay. The only other question I had was regarding the new water bodies rule, and you said that you hadn't lodged a submission to that. Right. Can you tell us what the equivalent rule in the operative district plan was? Presumably there were some rules around water quality and where they transact the subdivision.
Yeah, they related to what were identified as priority water bodies.
Okay.
And those were identified spatially on the planning map.
So there's been an increase in the quantum of the resource now.
Yeah.
And has the activity status changed at all?
Yes. Yeah. So it was an esplanade strips required alongside priority water bodies.
Yes.
It's now it's required along significant water bodies.
Yes.
And the number of those has increased.
Yes.
And it's required on all water bodies under 4 hectares
yes.
lot size.
And what was the activity status in the old plan relating to priority?
I think it was discretionary, was it?
And what is it now?
I suspect it's the same.
Okay. So the activity status has remained, but the application of the rule here now has a wider spatial.
Absolutely. Yeah.
Okay. And what was your experience in processing applications under the older one in relation to priority?
Well, it was very clear because you knew exactly what rivers and streams you had to provide esplanade strips.
They were shown.
So it was very clear.
Yeah, that's the process. What about the outcome? In terms of whether there was a requirement, was there some consistency in terms of when water body esplanade strips were taken from?
It was a requirement. So I don't think that we, alongside priority water bodies, I don't think they were waived. The width might have been reduced,
right,
but I don't think there was waivers given. I may be wrong in that respect, but I think it was mandatory. And those rivers were obviously significant, with rivers of significant.
Sure. Just finally picking up on the chair's point, I mean, if you were to want to leave some evidence on that particular role, and there were other submitters that you can identify, that's probably your best bang for your buck at the moment. That's in. And right, Mr. Dickey, you and I probably shared some time together in Dunedin around the early to mid 80s, I imagine.
You're right.
Yes, thank you, Mr. Sol, for attending. Thank you very much for coming along with the other surveying people who've been here today. I think, yeah, get together as a group, look at the range of submissions that are been done by the surveyors. And we'll certainly look forward to hear back from you on those matters that you can give us further advice on. Thank you, Mr. Sol.
Yes.
Okay. Can I just, there have been, look, also on the Zoom, I'm mindful of keeping tab with people on the Zoom. So is here, and there's Beth. Can you just introduce yourselves so we know who's listening in? It might be doing something else. Yeah, that's all right. So Ms. McBeth from the council team. Ms. here, is Ms. here from Grand Mount Petroleum? Okay, thank you. Mr. Gibbs. And I think there's some other guests here. Just stand up and identify yourselves. Yes.
My name is Home White. If I may just digress a little. I'm interested in new people. Mainly you, Anton. No here, boy.
Today, Mark, me and Kia koe tarana tira. No tauranga. No tauranga hau. No ngātirangi nui me maitarangi o kuiwi. E no ana I reira. E tipuaka e te taho o tamatau kaua me taku nei kuia. Ko taku māma no te motu tere a matakana. Ko taku pāpā no te kāinga iti o kohu maru. I te wā nui I te taho o taipā me maua nui I te tai tokarau.
E ato piringa kia Ngāti Waiora, coffins mā.
Ai, au nei whanaunga, ko Jenny May toku nei auntie.
I've just asked him who he is because his name is quite common. And it's part of our whakapapa. He is also part of the Ngāti Tama whakapapa. So to that end, I wanted to lay it out as to who you were. I'm not claiming a conflict of interest.
Just so everyone knows, our coffin ancestors are from a little place called O'Kane's Bay, which is on Banks Peninsula. So it's I think 12 houses long and 2 houses wide at the present time. And our ancestor Alexander Coffin came from another island called Nantucket Island. So Nantucket Island, O'Kane's Bay, that's like traveling to the other side of the universe. And 3 generations down from Alexander Coffin, large family, 9 children. 2 of the brothers went to Taranaki. My ancestor stayed at Opunaki, and the other ancestor went to Te Kuiti, Rohi Portai, and married into that family. So they're the Coffins on that side. And my ancestor went up north to a little place called Kohumaru. It's now in the bush now. It's gone back into the bush. And they moved, my grandfather moved to the big town of Manganui. So that's the connection for the Coffins here on my father's side, on the Pākehā side. But on my mother's side, she's on Matakana Island. Naitarani and Ngāti. Yeah. So kia ora for asking.
As a 16-year-old boy, I worked with Jenny May's grandfather, Charlie. I'm familiar. Well, I'm not going to waste too much time in telling you who we are. What I'm going to do is lay out what we've done, where we are, what we've done. Now, Otama is a group of Hapu who are land-based. Our land is some is within this rohi. Most of the land that we hold still in our management, still in our ownership, covers 8 councils, which in itself causes us issues. On my own property, I have 3 rurupa. 1 modern rurupa and 2 ancient rurupa. When I say ancient, I mean pre-1800. It's still in use. We have marae, we rebuilt marae. We have programs, we have bush programs, youth programs on those lands. Where I'm getting to with this is that council chooses to treat us as merely landowners who happen to be Māori. Let that sink in, at how that would affect us and our people. We don't qualify for any of the council grants. We get fobbed off. But we still exist as best we can. The people come today with me. I speak for the whole of Potama. These people speak on issues and how it has affected them. We have a claim within the report that has been recognised. We are now engaging with Te Arawhiti to progress that claim relationship. We don't want to call it a settlement because nothing ever gets settled. It's a relationship. And this is a relationship here. I've spoken to, since the District Council was formed, I've spoken to every mayor, starting with Claire Stewart. And those who were before, Claire invited us in to participate. When Claire was retired, we went downhill. So what I'm asking is for a fair suck of the orange for our people. We are affected by your planning. We are the kaitiaki of our land blocks. Let me qualify that. In my mind, we are all on this earth as kaitiaki. We are given an obligation to look after whatever is within our realm. In my case, I have something like 3,500 hectares that I manage, me and my family manage. And that's only within the New Plymouth District Council. Some of it's landlocked. We've cleared some of that away. Personally, we have invested our own money in opening it up. Because council don't see it as being a productive area, they choose to ignore it. And that's fine. It's fine. It was just established a very large bird sanctuary on one of the blocks. Now people have moved in. These are all hapu driven. It's not driven by a overall structure or a new structure. Each hapu has its own mandate. We'd like to have a relationship with everyone, but it would appear that that can't happen. We're going to be here forever. So let's get on.
Kia ora. Is it okay if I use that whiteboard for a couple?
Certainly, yes.
There or around?
Why don't we bring it up into the corner? down there.
Yeah.
You're in brand new. Make sure it's not a permanent marker. A permanent markers are not good on those things.
Not very good exploring, but something nothing here. So, yeah, already up there. But here we've got boundaries, we've got say qualify. And we've got I don't know here. We'll go down the middle. So within those boundaries, back in 1820s, say back in the early 1800s, all Ngāti Tama lived in Potama.
The northern part is called
Horotai.
Horotai. Okay, gotcha.
So what are we doing with those?
We've given some documents.
Perhaps Mr. Wallenhoven, Morning Tea said that you've given a stick with some documents.
Yeah.
How do you want to handle those? Because are there any of those you want to refer to, or?
I will when I sit back down.
Okay,
but then you can keep. I don't think I need them right there.
Okay, so carry on with the.
So within those boundaries, about 1800, all Potama and Ngāti Tama all living in those boundaries roughly. And then in the 1820s, there's migrations of people from there. Some of them went this way to the Wanganui, top of the Wanganui River. There's migrations to Chathams. There's migrations to Waiponamu, the top of the South Island. There's migrations to around Wellington area. And the Potama people stayed on that land. So as an example, one of the Hapuru Ngāti Wai, which is the Te Kawa, some of Ngāti Wai went up the Wanganui River, some of Ngāti Wai went to the top of the South Island, and some of Ngāti Wai stayed. So the illusion that there were clean migrations and splits is not true. It wasn't that simple. But the simplest is when the Crown comes along in 1840, roughly that's where people are, and there was a migration back to Pukearahi by some of the Ngāti Tama people from Wellington and about in the early 1860s, from back from the Chathams that went to Pukearahi to the south of Polynesian. So there's issues around when people say Ngāti Tama, and there's all these people in Ngāti Tama, but they're different branches of that Ngāti Tama, and it's easy to not understand whether it's a broad description or it's specific to each place. So I wanted to do that first to try and give some And then, so here roughly we've got an NPDC boundary. We've got Strat that sits on the back there somewhere. So we've got NPDC there. We've got Waitomo there. And we've got Waikato at the top, but different boundary than district councils. And we've got Taranaki Regional Council. We've got Horizons as well. And they all have different people, different plans. Some of them, like Stratford, only impact on the bank, and we haven't bothered ever going and seeing them because we don't have time to deal with that many councils. And we have a different relationship with every single one of them.
Mr. Gibb, how does Horizons come into the fray?
Off the back.
There's a
Towards Ohura.
okay.
So that just to give some context onto the history of people and council boundaries. So just to Kōrero, I want to talk about, so we remember you from the Mount Messenger hearing and appreciate courtesy, etc. A couple of the issues wanted to speak briefly, concepts about out of that and out of the council response on this, what is it, section 42. So the term recognition in the Resource Management Act comes out of that section 6, recognising and provide for the relationship. What's happened here is that the council looks at the term recognition and says, we can recognise you as tangata whenua, or we can deny you as tangata whenua. We can recognise you or not. It's nothing to do with the relationship. And so we have the same issue comes out of the blurring over the last 20, 30 years has come out of settlement, because settlement negotiations, because every time you see on One Network News, the Crown mandates settlement negotiators. But in the Resource Management Act, the mandate comes from the iwi or hapu itself. So we get terms blurring right across the people's perceptions. And so the council planners assume they can recognise or not recognise tangata whenua. And in this case, they've said we don't recognise. And as Home One said, Potama people own that land and that green boundary. Not all of it, some of it was taken by proclamation after in around early 1900. Some was sold, etc. So around in the section 42, the concept around mandating and recognition, it implies that it's council or Crown's role to confer those mandates or recognition or not. And I think that spilled over into your decision on Mount Messenger. You accepted that Potama was tangata whenua in that because you said, and the Pascoes were kaitiaki, which is consistent with what we said. But I think where the error went was that then you said Debbie could represent Potama. So then we have effectively the council or the Crown saying we can determine who your representatives are, who your representative organisations are. And we saw that as the error.
So to give that hearing is still in front of the courts, isn't it?
Yeah.
The final determination.
So we'll quickly run through. Yes. But it was just the concept, like we support the first part of what you did. And you said it wasn't your role to determine mana whenua or who tangata whenua was. We support that. The error that I think you made, and the court found something else, we'll get to that in a minute, but it was just that you made a determination of who should represent Potama's interests in a kaitiaki forum, and who represents Potama in any forum is a decision of Potama, not the council, if you like. That was all I wanted to bring up about that. So as to It's not uncommon, that desire for organisations to want to determine representation of Māori, Papu iwi or whatever. It's not uncommon. But I think it's got legs out of settlement processes because that determination of mandate by the Crown got a lot of publicity. It's just something that becomes accepted. So as to the challenge or leading to, or the challenge or is Potama Tangu Whenua. Well, in the Mount Messenger Environment Court decision, the court held that it was that they could do, basically they ended up doing an investigation, and in that information what was on stick. So if we look at number 4, the reserved judgment of Judge Harvey, and in our view, all the panel has to do, or the council or whoever, is look around and say, well, has that issue been determined? Not whether you have to do a full hearing of determining who's Tangu Whenua, but are there other decisions or is there other evidence where this is determined? And so that Harvey decision and the Mount Messenger decision, it said Judge Harvey made the following findings and observations which are of relevance. I think it was the Environment Court of Para 249, I think. And it quoted Ngāti Tama and Hapu affiliating with Ngāti Manipura, 1 through 2 in that one.
Charles, you need to blow that up for people like me.
It said at Para 132, Ngāti Tama and Hapu affiliating with Ngāti Manipura have been tongue to
Sorry, Mr. Gibbs, I think we're struggling to see that. So maybe if you can we fill the screen with that and blow it up? Yes, thanks.
Great. So down the bottom of the paragraph there. So the whole case was about, that decision was about us applying for a reservation on our land, and there was support from Potama, and there was support from Ngāti Manipura for that, and there was opposition from Ngāti Tama. And so that on the front page, New Plymouth District Council were also a party because they wanted to take land off us under the Public Works Act, so they opposed the reservation. So clearly in the bottom two sentences there, that Ngāti Tama and Hapu affiliating with Ngāti Manipura will be Tangu Whenua of the area in question for generations over several hundred years. Now, if we go back to Para 4 of the decision, and the last couple of lines there, it said the applicants are supported by Tangu Whenua, including Ngā Hapua Potama and whānau and Hapu affiliated primarily with Ngāti Manipura and Tainui Waka. The reason that Potama has traditional affiliation with Ngāti Manipura is because in those 1820s disputes, if you like, that was where Potama people were a lot allied with. So similarly at Para 69, Judge Harvey gave specific direction as to his Para 1 through 2, whereas right in the middle of that Para 69, so he's making a determination about Tangu Whenua, and about the third line down, it says those rights are shared with Ngāti Manipura aligned groups, including Ngā Hapua Potama, which gives, I won't take too long, but it gives credibility and direction to what the Environment Court said.
I just have a question about the timing of this. So Judge Harvey's declaration. When was this?
2011.
Okay.
So Harvey had sat through the petroleum inquiry, the Waitangi Tribunal petroleum inquiry, which Potama was a participant in. And in a previous life, before he was a judge, he was a lawyer at one time for Ngāti Manipur, so he knew who everyone was. So he carries on at para 80, 81, and 79 over that Potama being Tanga Whenua. And he also
So that was the determination that Judge Harvey made. He was answering that question. Who the Tanga Whenua of the district? He had to determine that and determine that case.
because he had an issue involving Ngāti Tama, Potama, and Ngāti Manipur. So the only other thing I think relevant in the para 136, where be on the bottom page there. So he's talking about, it crosses. He's talking about the last sentence on the top page. The only exception might be where one of the Tanga Whenua tribes gave their consent for the applicants to act as kaitiaki or custodians of those traditions. So the relevance there is around Potama endorsing or appointing kaitiaki. So the other most relevant evidence is Potama Tanga Whenua, I would say, would be 6 on that, Te Manawhatu Ahu, part 6. List. It'll be about 1,020 on the page count or something like that, but it's page 997 on the document.
Just to give this got an embargo stamp on it,
that was embargo, at least in draft.
Okay.
Yeah.
What page? 997. 997.
So it was embargoed to the claimants for a couple of days before it was publicly issued.
We voted up, Mr. Roy.
So there's a summary of claim at the start, and it's the claimants allege the Crown has breached the treaty by failing to adequately provide for the exercise of Ngāhapu Potama, Tino Rangatira and Kaitiaki over the Taonga peoples of the Hapu lands, waterways, etc. And it continues there, and over the next page, Scroll to the next page, halfway down. The heading there, bottom says, is the claim well founded? And it says this is part of the Roapai District Inquiry. Having considered all the evidence presented to us, we find the claim to be well founded. So we've got no doubt you've got, with just Harvey's decision in the Māori Land Court and the tribunal findings, that there's no doubt Potama's tanga whenua on Potama.
So this document here, Mr. Gibb, the date of this is
23rd of December 2020, 2020, yeah, 2020.
So the difficulty that caused us was the hearings happened at least 10 years ago, and it's taken 10 years for findings to come out. Wow. So the consequence of that is that it's no longer a claim, it's now a finding. And the where to from here is a different matter altogether, like how the Crown are going to redress their breaches, land wrongfully taken, etc. is a discussion to have. But it's I think all the panel need is our Potama tanga whenua up here. And in our view, there's a decision, there's more decisions than that, but the Harvey decision is the most clear, and tribunal findings. And
the chronology is that this document you have here is after you lodge submissions on the district plan.
That'll be right.
Those September 2019.
But there's we participated in the petroleum inquiry as well, and there's quite a section on Potama in that. And even the kaupapa tuatahi, the Taranaki report acknowledged that Ngāti Ake and the Hapu had an autonomy of their own. But they only had one hearing in the kaupapa tuatahi, that's sitting with Taranaki before having any further hearings. And the first legal determination about who had rights to Potama was the 1882 decision, which is number 1 on our list. And the Land Court decisions. The first one. So that was judgment, the Appendix 2 judgment on the Potama blocks. Over here. But the confusion that people have is if you flick onto the 1 to 3rd page, and down near the bottom, say last paragraph. So roughly where we, so just up from your cursor about 4 lines. So after the conquest, Waikato in the northern section of Ngāti Manipura returned home and took no steps to occupy it. And when you turn over the page to the last page, last paragraph, so the judgments of the court should be made in favour of the resident section of Ngāti Manipura, doubtless the northern section who assisted in the conquest, in other words, the section that went home. The confusion seems to keep coming from organisations like the Plymouth District Council that don't bother to talk to Potama or don't meet, as they run those Manipura issues together. And the resident section and the northern section are quite distinct families, distinct owners. And the next one on the list is a list of owners on the Potama block.
So these documents are in the
they're in that thing.
So they'll be put up on as part of your submission on our website.
Yeah. But the issues around who the different sections of Manipuru, etc., in Potama and Ngāti Tama, any confusion is because people can look at the 1882 judgment, and unless you know who the resident section of Ngāti Manipuru on Potama is, and unless you know the difference between the northern section, it's easy for people to say, oh, that's Ngāti Manipuru, it's not Potama. And it's the same issue with people talk about Ngāti Tama, and they're not sure whether they're talking about the Ngāti Tama that are living in Pukeariki, or the ones at the top of the South Island, or the ones up the Whanganui River. It's like we can say, oh, we're all New Zealanders. But when we're here, we're a bit more distinct. We can come from Tauranga, we can come from Auckland, we can come from Wellington or Taranaki. And even within that, we can be more specific. So I suppose the purpose of the cordial so far was council have said along the lines of they don't see that Potama are tangata whenua, and so there's no provision made in the plan. So the 1882 decision, what we were just looking at, the effect of that was to ensure the continuation of existing occupation, people on the land, marae, urupa, and wahitapu. And those wahitapu have been lived with, added to this day, and then they come into the district plan. And because the New Plymouth District Council refused a relationship with Potama, then when they're assessing wahitapu, they haven't included Potama wahitapu in the plan at all, unless there's been like archaeological sites identified by amateur or professional archaeologists, and then they've allocated them to Ngāti Tama, Ki Pukeariki or Trot. So there are quite serious effects from the lack of engagement or the denial. Like I'm looking at it's just section 42, and I think it's where he said it's Ms. Edwards put this together, and that could be you. Never seen you, never met you. We weren't invited to the Kaitiaki forum they have for the district plan. Haven't seen you up there, up at Potama, Marae, or anything. So as to confounding the two branches of in the 1882 decision, the resident section and the northern section, which is the Manipuru Trust Board, the northern section, whether it's ignorance or mischief, nevertheless the issues get confounded. And even in that, even referred to in that Mount Messenger decision, where Judge Dwyer says something about the Manipuru Allied Hapu, but if he looked at paragraph 69, he would have realised that actually Judge Harvey specifically acknowledged Ngā Hapua Potama as being that. Just from not being thorough, not engaging basically. So, just seeing how much of. So we have an invitation to make to the panel to conduct a site visit. Not sure whether that sits within your parameters, but it's pictures worth 1,000 words. And the invitation is there. Couple of specifics. We haven't, to be honest, we haven't gone through this district plan at all because we thought, well, if Potama is excluded from the plan as it is, the first thing you've got to do is get through the door. And we think there's some consequences of the denial of relationship, denial of existence. Well, it's not quite existence because say, oh, look at Potama as being landowners that just happen to be Māori. So we're thinking, what's the consequences of that hara? Is it that we've got a Section 33 delegation equivalent? Is it that we should be getting the Waitomo District Council boundary shifted down to cut the New Plymouth District Council off our rohi, which would make life simpler for us because we'd have one less council. If we got rid of the TRC, we'd have two. Because we are concerned about a begrudging inclusion. We see an inclusion is entirely different if you're included because you want it, or there's been an exclusion because somebody's made an error in looking at things. But if there's to be a begrudging inclusion, we think it's not really fair for the Potama whānau and hapu. And that, in our view, that's council's call. Probably should have raised this earlier. It was in the earlier quarter of that. It's common. We're not putting this on necessarily here, but it's common to reduce Māori rights, including Potama rights, to claims. We've heard it in a couple of other forums lately. But they're not claims, they're actually rights. And in the case of Potama, they're inclusive of land titles and all the rights that go with it. And that 1882 decision talked about perfect title. And this is the number 2 on our list. I need to go over it, but there's a list of 74 names or something of the ancestors of Potama people at that time that the land blocks were allocated to. Over a period of time, there's been partitions and splits and a whole lot of land taken for survey lands, etc. So those are different ancestors. The Potama ancestors are different than the Tront ancestors. They're different than Ngāti Manipuru ancestors. These are basically whānau and hapu ancestors.
For the commissioners, can you just Trump these?
Ngāti Tama ki popularity. The Ngāti Tama you're dealing with later.
Yes. Yep. Just I was aware of that.
Yeah.
It's an acronym that's used for
It's-
Ngāi
Oh, right.
Oh, right.
The Ngāti Tamarunanga.
Runanga or Ngāti Tama.
So the Ngāti Tamarunanga only represent a discrete section of Ngāti Tama people. For example, there's Ngāti Tama people up the Wanganui River, Chathams, Wellington, that don't qualify to be represented by Trump. So some of those people, their ancestral connection, they come in through Potama and not through Trump.
So we're not asking you to determine everything, we're just asking you to provide for our rights under a planning regime. Again, we haven't gone through this district plan. In our view, we were entitled to consultation and the council made a deliberate decision not to. We're not sure how the rules affect Māori owned land, like the subdivision put this morning. In our view, if we're doing partitions or license to occupy, for example, not sure where that sits in your rules, but we're not conceding any waterways or the water itself. Like, we're not conceding marginal strips to the Crown or Esplanade strips. And similarly with SNAs, the SNAs need to remain under the kaitiaki of the hapu, not the iwi authority as such, but the hapu that owns those. We've got 2 or 3 under Ngā Whenua Rāhui covenant already. Some discussions open, but Ngā Whenua Rāhui are pretty slow. So I suppose, so one of the other specific issues in the existing district plan. Our hapu had appendix 27, like scheduled areas, and we're pretty sure it's been removed out of this one. It was to address kaitiakitanga. We would like the scheduled area effect to go across the whole iwi rohi, and change in the text to accommodate that if we're going to stay under the New Plymouth district plan. But we don't, we're sure that it's not within the jurisdiction of this process to reduce potama down to landowners that just happen to be Māori. So, and I'm not wishing to retain subdivision. Section that schedule 27. Other than within the hapus themselves.
So schedule 27 is in the operative district plan.
Yeah. And it was the product of resolving in a what do they call it, appeal to the district plan. It's got a different name. Whatever the name of it, a consent order or something. Oh, that's yeah, they don't call it an appeal, they call it a referral.
Is there anything else you'd like to cover, Mr. Gibbs?
Oh, it's just a comment. That's how we met Ms. Johnson. She was part of the resolution with us. So, yeah. No, that's probably let's see if I've covered the documents. Number 7 is an potama induction video. We recommend that you watch it in your own time. It's about 8 or 10 minutes long. Request that you do watch it. And number 3 is the potama iwi plan. Lays out the rohi. There's some photos, there's some partial, there's hapu list, although that's not complete. Expectations, that's the iwi planning document. The hapus have started a process of hapu planning documents, but they're not lodged with council as yet.
So is anything lodged with council, Mr. Gibbs?
Yeah, that number 3, whakapuakitanga or potama, the potama iwi plan.
It's been
lodged a bunch of times. TPK had to lodge it the second time because the first time council binned it.
2010.
2010. And iwi authority, are you advertised on the TPK website?
We're not now.
Is that because
settlement negotiations? Basically, settlement negotiations take quite broad scope. Their latest reason for removal was the Mount Messenger Environment Court decision. And we haven't followed that up, but that's the reason they gave in the last couple of months for the removal.
Do you have that on writing, Mr. Gibbs?
I can probably find it. We intend to oppose this. But you know how much time you waste on each issue. Spent. So we're on the put on there in 2011 and removed in about 2021. Yes.
So we've got a meeting with Te Arawhiti scheduled, and that'll be one of the things on the agenda.
So remind me, Te Arawhiti, that's
Crown Māori relations, so that they are also opposite treaty settlements, but we've got a meeting with the Crown Māori relations part of Te Arawhiti, and that's one of the things that we will be addressing. It's not acceptable to potama that, for example, the marae aren't even listed on your national register of marae. Yeah, it's not accepted.
The marae won't be listed in your district plan if you have a listed marae. No potama marae will be listed there. Because council won't list them.
so I do have a few questions. So is that all we want? Yes. And just for everyone here, there is a a schedule of documents that has been provided on a stick, whatever they're called, and those will be posted on the website. We also have through the Zoom platform, we've got a record of the Korero as well. So I think we've captured the way Mr. White and yourself has presented the position. So thank you for that.
We tried to keep it.
Yes,
not too many documents.
No, thank you for that. Well, I do need to make a comment for the record of this hearing that I was the sole commissioner on a requirement by, in those days they're called New Zealand Transport Authority, Waka Kotahi, or a Mountain Messenger bypass. I am, and Commissioner Will John will correct me, that I'm what's called functious officio. I've done my job. Is that right?
Yep, sounds painful, but you're right.
Yes. I'm aware that the Environment Court on Appeal was heard by 2 Environment Court judges, a Maryland Court judge, and two other commissioners. There have been some decisions and some appeals on points of law, and that process is not concluded. So is that a fair summary of your understanding, Mr. Gibbs?
Yeah, the High Court found that their judgment was limited to the Mount Messenger project area.
Right, as a High Court. So we'll read, just as background, because you've raised it, we'll look at those. And that's probably about all I can say on that.
But we weren't claiming that you had a conflict of interest.
No, well, again, I wanted to just double check on that, because that's quite important. But we're here to hear and make some recommendations. And the other reply to your request for a site visit, we have asked all parties to let the hearing administrators know if they'd like us to do a site visit, if we are available, and just make a request through Straka. I do have a question about the scope of your submission. We do have the submission printed out in front of us. You've heard my questions about with the surveyors about just the whole question of scope and what we can manage to do with a broad submission, saying you object to the whole plan. Just reading through, is this, I think it goes to perhaps 5 or 6 paragraphs. Is this the sole submission? There's no other submissions on other parts of the plan, or not?
You just have to say that our capacity, especially at that time, but in general, is very limited.
Yes.
We're defending quite an attack by the Crown at the moment. So the Crown's actually funded totally to oppose Gautama. That includes funding for all their time, legal representation and all these processes, as well as NZTA's own legal firm, Buttle Finlay. Also, we've just learned that that lawyer's firm has been assisting with the NZTA funded Trump lawyer. So we are up against quite a significant issue here. So that, of course, has flow-on effects to dealing in all of the other things that we're dealing with at the moment, and the district plan is just one of those.
What time?
Time.
So when we're talking about, say, in the RMA, we're talking about treaty Waitangi obligations. What Reece has said, what the Crown are doing at Gautama at the moment, there's no level playing field at all. They're not only attacking, funding another party to make an attack. So
at many levels, and layers.
So we haven't gone right through this district plan. We would actually think it would be good to have we're either in it or we're out of it.
So your specific relief sought is if MPDC are determined to exclude Putama from their functions, powers and duties under the RMA, then we request that MPDC confirm their informal transfer of powers to Putama pursuant to section 33(2)(b) of the Act. So,
because they won't do it formally, they just won't do it.
And so I'm just trying to think about your starting position, Mr. Gibbs, that your claim, I think I wrote it down, and correct me if I'm wrong, that your submissions to us is that section 6E relating to the relationship of tangata whenua to sites, etc., you're saying to us that 6E applies to you, and therefore we as a panel should be recognising Putama and your interests. Is that
section 6, 7 and 8? Yeah. Yes. Yeah, but we can't force you to.
But also your relief is quite limited to what, you sort of haven't asked us for anything particularly other than the relief sought. But reading within the submissions, what if we? Yeah, I'm just trying to work out.
Well, if we're to stay in, then we would like those cultural rights of the hapu to be provided for. And I understand the difficulty around being specific, but we haven't had the resource to go right through the district plan clause by clause, and council made a decision not to consult. Like they put quite a bit of resource into consulting with tangata whenua, except Potama. And that's resource like right at the start, what plan direction that you want. And we have quite different expectations, even cultural values, than say urban-based iwi and hapu, because all this infill housing and that doesn't affect us. But as a generalisation, there's a lot more hunting, gathering, there's a lot more space. The waters are still within the control of the hapu a lot.
So Mr. White mentioned that Maori people that you're representing own and manage a range of blocks in that broad area that. Do you have a map showing those blocks?
Which specific areas?
Yes. Within the New Plymouth district boundaries.
The issue we've had in supplying information like that is that the council takes it upon themselves to allocate those areas to third parties. For example, Wahitapu, we can't identify most of the Potama Wahitapu because the council takes it upon themselves to designate it to one discrete section of Ngāti Tama. That's the direction that this draft proposed district plan is going.
So you don't have maps of the areas, or they're not able to be provided?
They're contained across TPK and Māori Land Court maps, etc. They're not compiled in one place necessarily.
But could that be done?
It could be.
And would you be concerned? And also, I'm aware that some Maori people are not happy with Wahitapu being identified and publicised.
Yeah.
Is there any concerns in that?
There are concerns around that because it's just like an invitation to damage.
So we can receive information under, we have powers to receive information under confidentiality if that was. So I think it's the invitation is back to you to work through the hearing administrator and provide anything else that you might help us in terms of identifying the scope of the interest.
There's a big difference between land that Potama still own and land that Potama in that block that no longer own as far as Wangitapu goes.
Understand.
Because Wangitapu, where the hapu still own the land, is not going to be disclosed.
Understand.
Because there's no reason for it. And the only danger is if the developer comes along and wants to damage it.
But if you own and control the land, you own and control the land.
Yeah. So I'm not sure whether your question is we can probably get a reasonable map of what land is still directly retained.
Retained, yes.
But there's the rest of the Potama block say there's a lot, most of it was taken by Governor General's proclamation and the Crown now manage it as conservation lands. So we still see that they don't have full rights to it either. Right. So we don't see that there's a diminishment of expectation under district plans of land that's lost.
So just to be clear, that whole area is Potama Tapu ancestral land.
I understand that, but I think I'm following on Mr. White's statement that there was certain land that is owned and managed by Potama. That's an area that I'd be interested in, and with whatever qualifications or guiding notes on it, and if we felt that could be helpful to us, and it's over to you, we would receive that. I think I'll hand over to Commissioner Coffin.
You've probably covered the questions I was wanting. I think we were all looking at this very similar questions, so thank you for the information already provided. Firstly, I think it would be useful having a read of the documents you provided. So I certainly I'm not familiar with them, so I haven't had an opportunity to read them. So there may be a later opportunity if there's questions that come up that we perhaps could give those to you later. Yeah, that would be probably able to do that. If there's something that's there might be more clarifications than anything.
And I appreciate that because it's better to ask for a clarification than to make an assumption.
Just on the idea of map, if you were able to, I'd be quite interested in understanding what are the remaining lands that are within your ownership and what's the rohe, because that's quite nice in terms of your general location, but it would be nice to see what, from your perspective, the area of interest of rohe was in relation to the New Plymouth district. That would be helpful because we've been discussing Mount Messenger, but there are things that are related to Mount Messenger, and there's obviously matters that are much wider than that. Would be interested to know the much wider part of that. But my main question is just around. I'm not necessarily so worried or fettered by the treaty settlement process. I don't know if you know my background. I've been involved in 3 treaty settlements, and they are what they are. They're quite a adversarial process that isn't very inclusive or facilitates good relationships. So I'm just putting that as a context, just putting that to the side for a second, and I was thinking, looking at this through Resource Management Act lens, and there is a tension there in terms of that Schedule 1 processes of consultation with tangata whenua through iwi authorities. And on one hand, that provides certainty for the council. So yes, we'll go to the iwi authority and they'll let us know who we need to go talk to at the tangata whenua iwi hapu whānau in a particular place. And that's the way things perhaps should, could, might, may happen. But it doesn't, but providing that certainty, it doesn't allow for the dynamic nature and social makeup of iwi hapu whānau and the way that they would like to operate. And that's a number of assumptions. And I just wondered, and then going back to the section 35, which I think you mentioned, 35A, there's the circular argument. You just keep on going back between the schedule and section 35, and you never get to an actual outcome that is going to be advantageous. And I wondered whether you had a particular view or some helpful advice in regards to that. And I'm thinking way back before the RMA, back into the planning tribunal, and there's Ngāti Kahu versus Tauranga District Council. That was a case where the local hapu hadn't been consulted by the council in regards to the district plan, irrespective of whether they'd sent a letter to the trust board. And in that case, consultation hadn't occurred, it needed to be done, and as a result of that, it was quite a landmark case. case, a number of quite significant changes were made to the way the council operates and deals with not just iwi, but hapu, mana whenua. So I'm just raising that, and then there's most recently we've had some High Court cases, and other cases, particularly in Auckland, around the scope of a hearing or a complaint who aren't mana whenua, and the processes that we as decision makers should take into account. And I think you've covered that part of things, but be interesting to hear what your reflections or advice are to us in that regard. In terms of, I think what we're talking about is consulting the tangata whenua, and there might be iwi or iwi authorities, or there might be others.
So thinking about the last thing first, we should probably lodge our heritage protocol. Once lodged. It's number 5, and it contains a specific statement of the roles of the iwi authority is to support, and I'm misquoting it, to support an advocate for the hapu, because the hapu and Hautama hold the autonomy and the authority, not the iwi authority as such. The iwi authority is there to advocate and facilitate. The hapu retain their own land and their rights. And I suppose that Ngāti had decisions over somewhere in the Ilfos, the latest one.
I was on the original panel that made the decision, and I should qualify that, saying that the court was hearing a case that bears no resemblance to the case that we did. Isn't that what just panel was saying?
And that was actually a strong subject in the management of the petroleum resource inquiry, that case law that affects Māori is generally started from an issue that didn't affect Māori at all. The case is a peripheral part of it, not
because it was mostly the residents who were concerned about the devaluation of their homes.
Yeah, but the important thing out of it, I think, was that the hapu involved said they're the ones that determine their cultural values, the depth and significance of them, not council planners, not someone else, and not Arawhiti or OTS. And I think that's relevant to here. And totally agree with your point around settlements, and our understanding of why the Crown embarked on a treaty settlement process wasn't to help Māori at all. It was because there had been some landmark court cases overseas where Commonwealth countries, especially in the US, had huge liabilities for breaching treaties with Indigenous people. And the Crown looked at the fiscal risk to the Crown, not to Māori, and decided, let's look at all the tribes through New Zealand, and let's see if we can get some of them to settle at 2 cents on the dollar or whatever to reduce our fiscal risk. And I think you referred to it is that, so then settlements are around breaches and a very poor remedy of those breaches, and they're not designed or intended to define what the originating rights are, the rights and responsibilities at all. And so when we get, I won't say his name, but I can picture someone out of Taranaki Regional Council saying treaty settlements are the limit of our responsibility to Māori, then we're in the endless circle with consenting authorities or regional authorities, except district authorities. And that's the difficulty we have, because they make that broad statement. I'm sure he knew it wasn't true, wasn't defensible, but he looks at Hautama and says, well, what are you going to do about it? And that's the situation Māori seem to sit in right throughout the country.
So just in terms of your relief that you're seeking, quite
so, okay, with the relief, we want that hapu rangatira provided for. And that's inclusive of some of the lands, like especially the Crown land, because nearly all the dock land up there was taken by proclamation, and everything south of the Tongporatu River was taken to survey lands. So the iwi lost most of its land around survey land. They leased out the Hokitina block to pay the survey liens, and the lessee never ever paid them and ended up with the title, whereas mortgagees mortgagees got the title. And then the Crown took everything south of the River as on top of that to pay the survey needs. So there was quite a harsh outcome of poverty with those large land losses. So we think that, like, when you're getting, say, on the muddy land blocks up there, that if there's partitions or license to occupy, they should not be triggering losses of esplanade strips and or community funding, because we're already badly, Māori are economically and socially disadvantaged anyway. And say just issues like Urupa, where is versus cemetery. As I understand it, half the cost of cemeteries a user pays and the other half's paid for by the wider council ratepayers, inclusive of Māori landowners, where in comparison, Potama are managing and maintaining their own Urupa and paying 100% of the cost of the maintenance, capital value, whatever, and having to subsidise the wider community.
They're wider issues, I think.
I know they're wider issues, but there's like having to make community contributions, like Marae are a community contribution, and the Hapu that don't have a Marae have an expectation from a builder, don't expect to have to pay community development levies, etc. Or if they're doing something, have to pay penalties to other organisations.
Thank you. Very helpful. Thank you. Yeah, I won't prolong this. Probably of the four members of the panel, this has been the greatest learning exercise for me, based originally in Canterbury and now in taking 2 pages of closely written notes. As Commissioner Coffin said, we will be reading the documents on the stick, and if there are any questions or clarification, we'll forward those through. But I do have a specific question, and it's I guess it's qualified by a comment that there appears to be some dispute or some ruling needed on what the scope of the submission actually provides for, and that may require some legal advice. But just for the moment, assuming that there is some scope to make some changes to the district plan, your submission, your relief seems to be in 2 parts. One is you either make some provision in the plan, or you exclude us through section 33(2)(b). I note your comment about begrudging inclusion, but my question I have is, if there was some inclusion, what would it look like? Is it, and excuse the simplicity of this question, is it simply including the name Putama alongside other iwi and hapu in the district plan, or is it more of a bespoke solution? Because just before you answer that, you said earlier about one rule for all, and I'm guessing that you're not seeking any specific, at least at the objectives and policies level, provision for Putama compared to, say, Ngāti Tama.
I'm not sure. I'll answer what I think part of your question is. We would expect a seat at the table of consideration of resource consents with the water, for example.
And you expect the district plan to
provide that. We're not asking for a right of veto.
No.
Like we've got long-standing experience and relationships, say, with pipeline companies, for example, and say doing some quite major projects like realignments in amongst Waikato.
Yes.
And not district plan identified Waikato, but Hapu.
I understand that, but that seat at the table presumably would be no different to the seat at the table that other iwi or Hapu enjoyed.
I don't know whether they got a seat at the table.
But assuming they did have.
Assuming they did have, but we're asking for it even if they haven't asked for it.
Okay. Yep.
Like there's been a lot of publicity over council wards and seats on council. That's a quite a high level issue, and the involvement can be in a lot of things that don't affect you. Like over the years, we've been sent consultation documents on toilets in Inglewood, for example. Basically 3/4 of an hour drive away from everybody anyway.
Yeah.
And, you know, while we want good environmental outcomes over there, we're not going to spend any time involved in it.
Sure.
But the environmental outcomes where we are, where we are, we want a participation. We actually saw that as being a lot more important than appointees to committees. I understand the importance of appointees to committees, etc., because you get a voice to make sure probably that you're not shut out like this. But the real is important. Specific.
If I just clarify my question a little bit more, the current district plan includes objectives and policies, some methods and some rules, some schedules. That, if I understand your submission correctly, excludes any reference to Patara.
Yeah.
And so the question was, are you looking for similar references to Patara that exist for other iwi and hapu, or are you looking for a more bespoke provision for Patara in the district plan?
Well, I think as a minimum, we're asking for that inclusion.
At a level playing field.
At that level playing field, but I think we're also asking, say, for stronger input where we are.
Yes.
And so the suggestion around that schedule, appendix 27 scheduled areas.
Yes.
We actually raised that a long time ago with council, because they had a long time ago, before when they first started thinking about the next district plan. How were they thinking of dealing with that schedule? And they didn't have any idea. And in our view, that might be an appropriate way.
Might be or might not be.
Might be a schedule like that, but across the rohi. So obviously the text in it's got to change to provide for those cultural values, because we're basically talking about the plan's focused on development. Because the status quo, you don't necessarily need consents. So a lot of the effects and impacts in a plan come from development.
The mere fact that I've asked this question probably indicates that it's not a clear-cut situation in terms of scope. And the fact that we're discussing on the hoof, if you like, some of the relief possibly indicates the difficulty in actually ascribing scope. But that's for another day, I guess.
Well, the best place to make a difference is at the start when things are just concepts.
Yes.
And that was inclusive of district plans, but we didn't. Yes. We weren't able to participate in that.
Yes.
And the difficulty we have with this district plan is that we've participated in the existing one, having, say, on a hapu scale, basically, not a unit scale. If the time to put your concepts up is when the plan's still at scope stage, the new plan, and we weren't able to participate in that. And as you go through all the processes, I suppose you get a better understanding of what's in there.
That's true, Mr. Gisborne. You did have an opportunity to lodge a submission seeking specific relief to the plan when it was notified.
Yeah, well, to be fair, we hadn't actually gone through it.
Yeah, I understand.
Yeah.
If there's some uncertainty about the scope to include provisions in the district plan, I'll say if there is, perhaps there's less uncertainty about your other relief, which is if you don't do that, council then you wish to transfer the powers of the Tamu pursuant to section 32. 33. What would that look like? I mean, I've not come across councils that have done that. Are you aware of other councils involved?
I'm aware that no council is, all councils have refused to do it through the country. So it's one of those laws that's put in place but never been effective. Because no one gives away their powers and right to get funded. It's not in human nature to give away power.
That's my final question to you, but I just have a question of clarification from Ms. Edwards or Ms. Ritchie. Were there any further submissions, neither support or opposition to the submitter on?
Yes. Submissions in opposition.
Yes, further submissions, that's what I mean. And they'll be in your appendix, they'll be in the appendix. Thank you, thank you, sir.
Thank you very much, Mr. Gibb. Just wouldn't mind putting some timeframes around things. When do you think you could come back to the hearing administrators with the plan of the land under your ownership control management?
Monday.
By the end of the weekend at the latest. We'll do it as soon as we can. We might have to.
So Monday,
but we'll see what we can get back to you.
well, I think just we should put a date on that. Monday, what's today week? So we've got the 27th to the close of business on the 26th. Thank you. And just one final comment, just an official request for the site visit. And just have a look at the hearing procedures about how we have to manage those. So we'll have to organise, we can't come and talk to you, we have to have a guide that's not involved in the submissions. So, but the stroke and the hearings panel will be able to organise that. So thank you very much. We will take on board your submission. Thank you.
And how many here?
We are running behind time, as we tend to want to. We do have Ms. Marco Aldrich and Mr. White, Big White, Caroline Bratt. We're effectively, I think, a whole session behind. I do think, I never like rushing people. I don't want to sort of be shoehorning people in. So with your, I suppose, I'd like to request that we have lunch now, and then we come back afterwards and we'll just proceed through the hearing. So thank you very much for sitting with us, and we'll see you back, I think, at 1:15. Is that long enough to grab a bite? 1:15, thank you.
No, don't.
Now I haven't presented any evidence, prepared any evidence, just got some speaking notes. And I've just, after this morning session, printed off the relevant sections in relation to statutory acknowledgement from the Te Atua Claims Settlement.
So welcome back, Ms. Rand and Ms. Ing. We can see you. You're back with us?
Yes, we are.
I'm sorry.
We can share. We just
No,
one for
yeah, it's all good.
Next month. Okay, so tēnā tātou, anō. Thank you. Thank you again for the opportunity. So as you know, I'm Sarah Mako, one of the Tautai Te Koteitanga o Te Atua Trust. So as mentioned, I didn't submit any expert evidence as as I'm generally supportive of the section 42A officer recommendations, and only intended to provide a little context and clarity to some of the statements in the section 42A report, and also to answer some of the questions that were asked this morning as well.
Just before you do, can I just clarify, is the TROE solely a further submitter on these matters, or did you have an original submission?
We had an original submission.
As well?
Yes. So I think the link in there is to our initial submission and our further submission.
Okay.
Yeah. On the timetable. Do you want me to read through this?
I know, I just misunderstood there. I see there is 2 separate matters here now. One's just called EFS.
I find it helpful, just take us through. Yeah.
Cool. So just in relation to the section 42A report, the general miscellaneous matters. So just there, I've just referenced the heading and then the relevant paragraphs. So iwi hapu consultation engagement, participation and funding, so paragraphs 30 to 34. I agree with the comments made in these paragraphs in relation to the Tiko Teitanga submission. The direction of the plan in relation to the engagement of cultural expertise should be articulated in the plan that it will be a user-paced approach. The Record Street subdivision, reference in paragraphs 37 to 40. So this is outside of the scope of our submission, but just to provide context, that's a Tiko Teitanga or Te Atiawa subdivision. So that was the first development undertaken by the Te Atiawa Iwi Holdings Limited Partnership, which is the commercial subsidiary of Tiko Teitanga. So the subdivision was named Te Kiukiu, so after Honeropiha Te Kiukiu, so one of the rangatira of the whenua. Resource consent was granted in 2018 for the 14-lot subdivision, and it was the first subdivision to have a street name in New Plymouth entirely in Te Reo Māori. Te ara o Ngā Keiha, so Ngā Keiha was the mother of Honeropiha Te Kiukiu.
So Record Street's being deferred to another hearing, is it right or not?
So,
no, I got it wrong, right? Carry on. Sorry.
So just parts of there were submissions in opposition to the subdivision.
Okay, that's just background.
Yes. Okay. So just to provide background, that was the Te Atiawa Iwi Holdings Limited Partnership subdivision. And if you do want to do a site visit, it's beautiful. So point 3, reference to identified features, so paragraphs 49 to 51. I note the recommendation that the defined terms and any references to features shall be dealt with through the relevant section 42A reports for those chapters. I consider it is necessary to extrapolate those features for clarity. For example, many sites and areas of significance to Māori, so SASM, are identified and scheduled. There are still many which are known and unmapped. There are also many which are unknown. They still constitute historic heritage. There needs to be the appropriate objective and policy responses to this, and as well as definition. The importance of engagement with tangata whenua. As mentioned in hearing 1, I considered it more appropriate to engage the expertise of tangata whenua to inform proposals rather than consultation. Engagement is a two-way sharing of information. Consultation historically in New Plymouth has, in the experience of Ngā Hapu o Te Atiawa and Tiko Teitanga, in some instances amounted to only the sending of an email. The benefits of genuine engagement and the examples provided in my evidence to hearing 1 have resulted in terrific community outcomes. Now, I just wanted to add, obviously, Mr. Dickey and Mr. Souls presented this morning as well. Actually, some of the other surveys, including Mr. Olsen. I think there's been a real, I just wanted to note that there's just been a transition for them as well. We know they've really taken it on board around the statutory acknowledgements and responding to those. So although they maybe raised some concerns about it, I think there's a real genuine intent from the surveying community and the development community to respond to that. And we've got some really good outcomes through some of those developments as well. So just wanted to note that.
Might there be something that Iwi Hapu could initiate themselves to keep surveyors in a room and out and have a look and have a chat? That's sort of quite outside this process. Because the world has changed on them with the PDP. Just thought, I think most of the people there were probably.
Definitely, it's been that intention as well, and as part of the management plan, having a sort of a how to use guide for our management plan as well, and then also and even a how to engage. I think they're often not putting words in their mouths, but you know, they think of EV and Hupper as just being a doorstop straight away, a handbrake straight away to development. So the example that Mr. Dickey gave as well, that was within Te Atiawarohe. We engaged with the applicant directly as well, and so it triggered, though it was a minor boundary adjustment, it triggered the requirement for the Esplanade strip. And in most instances, you'll find that we will always be supportive of the Esplanade requirement for access for customer purposes. And in that instance, we said that. Obviously, it had a large balance allotment as well. And we said that we would be open to other mechanisms if they were available as well. Just because we understood the relationship between the applicant and actually the owner of the land as well, and there was a reluctance to take this. So we're always open to working and finding those other mechanisms as well. But it's just to share, yeah, we've definitely been engaged in that particular subdivision as well. So number 5, just reference to Mātauranga Māori, so that amendment accords with the Te Kotahitanga submission, analysis of submissions on key issue 4. So Te Kotahitanga is not listed as a submitter to that particular submission point, but I thought it was necessary to just outline that. I think that has a reference to the requirement for reference to scheduling, links back to that reference to identified features part as well, in terms of the rule framework and the objectives and policies as well. Number 7, economic development consideration. So we accept that, accept that new technologies will create new activities and encourage the engagement between the CCO and Union Hub. So section 42A report, part 1, introductory general provisions. Supported all of the provisions, all of the recommendations there. In point 5, how the plan works, the general approach. So the classes of activities. So I understood there's I think Transpower from memory had requested some changes around those catch-all rules. So well, my understanding was that there was a catch-all rule within the zone chapters. Some of those catch-all rules have have a permitted status right through to a non-compliant as well. So it varies between those zone chapters.
I think Ms. Margaret, the issue is what is the wording to distill that catch-all? There's a couple of different options.
So I've made a point here as well around analysis of, so point 6, analysis of submissions on key issue 3. If the strategic direction of TW8 is going to reference shared decision making, I think that needs to be set out in the plan. However, I don't think it should only be limited to the Manawhaka Honoarohe agreements. I think so we're working through a Manawhaka Honoarohe with or what that could potentially look like with MPDC and TRC at the moment.
Where are they up to? Like I've seen some reference to them in the 42A reports, but where are things up to with those agreements generally? Are they being actively worked on by the,
So we have there's an independent facilitator working on those independent facilitator, best way to describe it, to draft for us collectively what that could look like. I think there was initially, in the initial parts of the discussions, I think the authorities, maybe one particular authority thought there was going to be a pan-iwi mana whakapono, but that won't be the case. So each iwi will have a separate mana whakapono with each, if we decide to have one of those agreements.
Who is it again facilitated the service?
Tina Pura.
Okay.
So we are hoping that it will be this month. We'll have some sort of draft of what that could look like. And that will vary for each iwi as well.
Thank you.
So section 42A report part 1 times whenua, so analysis of submissions on key issue 1. Support the recommendations within these paragraphs. In my opinion, Todd Energy missed the point of what Te Koteitanga is trying to achieve within that submission point. Only tangata whenua have the expertise to advise on what developmental decision will affect them. Point 2, analysis of submissions on key issues. Look forward to the discussion around the water bodies chapter and activities within, adjacent to and directly affecting our awa. Point 3, again, that makes mention to the mana whakapono here. I guess we're concerned we don't want anything in that front end of the district plan to limit us in terms of what an agreement could look like. So as you know, we could implement a section 33 under the RMA now, so it shouldn't just be limited to just section 33 or just to notification, for example.
Is the expectation to have the agreements, the Rohi agreements completed this year? Like, I'm just thinking about timing. We're certainly interested in following those, or
so I think it's going to be a much more lengthy process than we think. There hasn't been any engagement with our hapu. Well, this is just for Te Atiawa, so we haven't had that engagement with our hapu around what that looks like.
Okay.
And of course, hapu can have their own mana whakapono arohe agreement with the local authority, provided the local authority agrees to that.
Yes.
That's my understanding. So, yeah, it will be a work in progress. I guess the thing is the Taranaki Regional Council in their in the regional coastal plan, it actually refers to mana whakapono arohe agreements within all of the provisions. So there's a different pressure to get one solved for the Taranaki Regional Council than there is with the New Plymouth District Council.
So we'll just hear from Wisdom Switchy about it's interesting. It's a separate process, I know, but it does tie in the scheme of things.
And so just some of the questions that were asked this morning. So there was a question around sort of tangata whenua versus mana whenua. So yeah, my understanding is that that was discussed at length during the ngā kaitiaki within the working group. I think Ms. Ritchie mentioned that this morning as well. And I would be inclined to stick with tangata whenua as well. I know it's mentioned in the Act as well, and not stepping outside of my lane. I've seen that there's some case law that does reference the use of tangata whenua as the most appropriate in the plans.
Okay, that's good.
I guess what we've said this morning as well is it's an interesting.
They're different words and they have different meanings, don't they?
Yes, of course. Yeah. So statutory acknowledgement.
Yes, yes.
Mana whenua is defined in the RMA.
Yes, as well. Yes.
A customary authority exercised by an iwi or hapu in an identified area.
Yes. So if I can give you, I can just share with my own experience and not if it's being tested. So I would always say that Te Atiawa, the tangata whenua, but so Ngāti Rahiri, Manukurihi o Tukatapu, that they are the hapu within that area, and they exercise that mana whenua there. But I guess tangata whenua keeps it much broader, and it takes into account other interests and historical events as well that may have happened in that area. So one other example that I've got, just thinking about that is, and this is probably a little bit different, is at the Taranaki Cathedral, so just on the one-way. Ngāti Te Whiti have been working with the Taranaki Cathedral over a redevelopment there. It's based around reconciliation. So Te Whare Hononga is going to be the whare that is going to be built there. At the Taranaki Cathedral in the grounds, 5 rangatira from Ngāti Haua are buried there. So as part of that redevelopment, we've engaged with Ngāti Haua as well, just because they have that interest as well. And that's how I see that applied.
Okay. So there is agreement about terminology in terms of how the plan. I see through the Kuitua report there, you obviously use some acronyms and the words to use. There's been some refinement as we go along, but it seems to be pretty close. Is that a fair statement in terms of just the way names are used in the plan?
Yes, I think so. Yes, I think you'll see that in my evidence to the first hearing, it had different spelling of Te Atiawa, based on some linguists that are now work in our office. But of course, yeah, there's many different spellings for Te Atiawa as well.
Of course. So we're having a little side conversation about how manawhina is being used both as a noun, adjective, and verb. Yeah. Linguistically problematic.
So point 2 is a statutory acknowledgement. So I've just provided there for you sections 29 to 41 and also Schedule 1 of the Te Atiawa Claim Settlement Act. So it just sets out the process for statutory acknowledgement, particularly in relation to resource consent. So we receive summaries of all resource consents that are received, which affect, I'll check that, which activities within, adjacent to, and directly affecting our affecting the statutory acknowledgement. So,
and who decides that?
The council decide that at the moment. So that is my understanding, is that's decided at the vetting stage, whether or not it comes to us.
So at the back of the document you've given us, there's the area subject to statutory acknowledgement and the location is shown on O2S 043. Are those plans?
Yeah.
Okay, so they are mapped.
So they are, Mr. Ritchie will be able to give further detail about this, but yeah, so those are all mapped and they're all recorded in the deed of settlement.
Yes.
So that, and with those maps, that's a statutory statement of association. So that provides that cultural, traditional, spiritual, and historical. It gives a statement. I think they're not as thorough as they are. You know, I guess that's the mechanism for the statutory acknowledgement, is that we can assess it then and there.
Okay, but there was still some interpretation to some degree about what you get notified and what you don't.
Yes.
And it comes from the council team. Just as a guess, are there lots of applications in your row that come through that you never see?
Oh yes, definitely.
Yes. And you're happy not to see them?
That's a work in progress.
You don't know what you don't know.
No. So you heard my questions of the council team earlier. In terms of preference to know, be able to see applications that come in before the process.
So as an example, so last month we received 70 applications. Between 2 of us, yes. We received 70 applications. So
from New Plymouth District.
That's New Plymouth and Taranaki Regional and Stratford as well.
But all statutory acknowledgement areas.
Only statutory acknowledgement, yeah. So I've got yeah, the next point was that question around the sites and areas of significance to Māori. So those tend to be dealt with at hapu level. So we will receive a copy of them as more as an information. And so our role at Te Teitanga is to offer that support and assistance to the hapu.
So what should the plan policy guidance be saying in relation to SASMs, sites and areas of significance to Māori? Should they be bundled with statutory acknowledgement areas where they're not part of a statutory acknowledgement, or should they be kept separate? That was the question I put to Ms. Ritchie this morning. Because at the moment there's an operational mechanical policy operating in the resource consent team. Here's a chance now for the district plan to formalise that policy and provide direction so that there's certainty for parties.
Yeah. Can I defer questions to the hapu? I think that's a.
Well, what's Te Area's position on it?
Oh, we're happy with how the arrangement is now that we're there to support the hapu.
So if the plan just refers to statutory acknowledgement areas and is silent on sending applications that affect sites of significance to Māori, Te Area, we would be happy with that. Not a statement.
How so we would be, so then we would receive all of the applications and the hapu wouldn't receive any?
I don't know about the hapu, but I guess what Ms. Ritchie told me is that there are some sites of and areas of significance to Māori that are not part of statutory acknowledgement areas. I don't know what percentage. It might not be a great percentage, but at the moment the policy direction focuses on statutory acknowledgement areas. So it doesn't give a direction, as I understand it, on sites of and areas of significance to Māori. So by that policy direction would ensure that the iwi receive applications which are within adjacent to or directly affecting statutory acknowledgement areas. So where sites of significance to Māori are not part of a statutory acknowledgement area, you might miss out.
Would that provision would trigger that under the SASM? That's how Tangata Whenua would receive it. I guess
only where a site of significant is part of the statutory acknowledgement area, but if it's not part of the statutory.
Are you saying, sorry, if it's not scheduled?
Yes.
In that, yeah.
Richie, we got clarification.
Yeah, I was just about to say that so the question turned on notification.
Well, whatever that notification means.
Yes, yeah. And so in my head, the trigger for SASM notification essentially is the rules, the SASM rules. So if anybody applies to do anything that's going to be within a certain area of a SASM, the rules are triggered to allow, and obviously, even though there's no specific notification, we'd automatically, downstairs would automatically go to iwi or hapu, whoever is.
That's another of my question, Ms. Ritchie, and that's something that came through from hearing one. I asked Ms. Edwards about this, about are we relying on section 95, or is the plan playing that role in identifying and having statements on notifications? The answer was we're going to rely on section 95. So it's now developed now to the extent that I'm aware that there might be sites of areas of significance to Māori that are not part of the statutory acknowledgement. The policy trigger wouldn't ensure that that Sarah was receiving those unless there was an unofficial or some other policy operating within the resource management team. But it seems sensible to me that the plan provides some direct guidance on this.
A formal statement of notification.
And then the SASM rules that are triggered don't benefit from a statement in the plan as to how you're going to notify, who you're going to notify. And I'm just wondering if is this an opportunity to provide some formality to do that. Sorry, that's a very laboured statement.
Thank you for the clarification.
Yes.
You have to have scope though, wouldn't you?
I think we're scope.
Yeah, and I don't know if there is or not, but it seems to be a live issue.
Yeah. So just to flip that on its head as well, so an example of where some of our awa are actually probably all of our awa, which is statutory acknowledgement. Some of our hapu have said, you know, they're our wahi tapu as well. They are our sites and areas of significance. So why don't they have a?
Yeah, and I'm looking from a section 32 point of view. Well, Sarah Wood's indicated that there's a greater focus now on engagement. One of the TW objectives talks about greater, and I'm just wondering what's the method for achieving that. It's one thing to have an objective that asks for greater engagement. The method might sit outside the plan, I accept that, but it might be more transparent and honest to have the method sit inside the plan. I was actually, when I read that, I was expecting some statements of notification in the plan. Clearly that's not the case. So the surrogate for that is the statutory acknowledgements, which don't always include SASMs and don't guarantee that the SASM rules don't guarantee notification, even though internal policy might cover it up.
Yeah,
just about being transparent.
Yeah, definitely. Yeah, I just, from the top of my head, I can't think of any, just off the top of my head, any statutory acknowledgements which have a site and area of significance to Māori overlay as well.
So you're not giving expert evidence, so we can get feeling around the room if others would like to.
I mean, I can think of some, so I can think of it. Well, at Pohokura though, you would almost say that the whole site, and there's tributaries that run through there. So if we didn't get it by statutory acknowledgement, then Ngāti Rahiri would get it by SASM.
I can't recall what the section 32 report says on this, but maybe that it's happy to rely on non-planning methods to achieve the objective. Similarly, it may be more direct.
Yeah, and I think that in my opinion, I think we need those methods in there, definitely, because I think there's been issues with non-methods.
Non-statutory methods.
Non-statutory methods. Yes. And one that will come out probably through the SASM discussion is around maintenance of, particularly in relation to network utilities.
I don't want to be seen to be leading this. I mean, and regardless of whether it's a kind of whenua issue or not, I would have the same questions on any other matter that said increase the engagement with a certain group, but then it's not clear what the method of achieving that is.
Certainly good line of questioning, and in terms of the staff, there's a clear objective. How is it implemented through the plan? As a practitioner,
I mean, I see that there's sort of two different things going on here. One are the obligations under the settlement legislation, which does not necessarily lead to rights under the Resource Management Act in terms of participation on the resource consent. And then you've got your sites and areas of significance. And I mean, the obligation under the Settlement Act is for the council to provide a summary of applications for resource consents within, adjacent to, or directly affecting a statutory area, which is what you pointed out. That has to be given to the trustees, who are also defined in the Settlement Act. So it's quite clear about the obligation there. But whether or not that gives Te Aotearoa a right then to petition the council to say that the application ought to be notified, you're on the same. You're in the same position as every other landowner. I mean, I don't say that dismissively, because you'd have to show that the direct effect on the statutory area that led to you being provided notice of it was an adverse effect that was more than minor, for the council to be persuaded that it ought to notify the application in the RMA sense.
Or notify in a minor sense.
Yeah, well, that's at 95B. The statutory acknowledgements, I don't think, give rights to general public notification, only limited notification. Yeah, so you can have your statement at the top about how that process is supposed to work under the settlement legislation, but it doesn't necessarily guarantee, notification of resource consents, which I guess to some extent puts the onus on Te Aotearoa to call up said applicant and say, hey, look, you do know that you're next to this area and we'd really like to come and talk to you about it. And we're not going to be, difficult about it, but we need to have a chat about it. And then to some extent, the applicant is on notice then that you're interested in it. Which is probably not a bad thing. Yeah.
Which is, I think, to date, so in the 2 years that I've been with TLTL, we've really relied on MPDC to help us with that engagement. So probably most, I couldn't tell you how many, most applications are put on hold under Section 92 to address those initial comments we make, and then we'll have that engagement via that process. But also we're finding that applicants are tending to engage at pre-app stage now as well, and are using the FEMA management plan as that initial, what are they going to say to us? In most instances we're saying exactly the same thing. We want that protection of the water bodies, we want the restoration of the water bodies. So most that have come on board with that as well.
It's quite interesting how the section itself's got a limited duration, like 20 years. So what, presumably in 20 years, the world's going to be a different place. All the past is cured and Te Ahiawa are on the front desk of everything.
Yeah. Well, and that's part of the mana whakahono having those discussions around Section 33 as well. Is the mana whakahono is probably going to be staged if we do agree to it. I really wanted transfer of powers in the first year, but I just got told no.
Yeah, get in line.
Yeah, so we're looking at that 20-year time frame as well.
Interesting. Have you ever come into an argument with the council yet as to what, and if you perceive a difference as to what directly affecting the statutory area means? Because depending on which lens you look at it through, it could be very different. I mean, one very extreme view could be a very Pakeha view, which is, I'm not touching your land, therefore it's not affected, versus, well, in fact, it's within an area that causes great cultural offence, and thus that is an effect. Have you come across that discussion with council yet?
I haven't so much had to do it with the council, but some applicants that we've come across have used that. We've been doing this activity for 100 years. That's not affecting your statutory acknowledgement. So that, those activities of cultural offence are.
Could it ever work another way around, in which council just gave the trustees a summary of all applications, and then it was up to the trustees to identify to the councils which ones it considered came within those? Well, it doesn't get you anywhere then, because it still doesn't guarantee any rights of submission. So
yeah. So we haven't been identified as a affected party or limited through the limited notified process to a statutory acknowledgement. Well, not my understanding. So in the last 2 years I've been with Te Tani, definitely not, but
so you generally just file, not just, but you file comments when you receive the summary, and you might get a full copy of the application, make comments, and that's filtered into the Section 95 and then the 104 decision.
Yes. So we actually receive full copies of the applications.
Yes. Okay.
We don't. Yeah.
That's good.
In my experience, the interpretation of that sort of phrase within a local authority is very much depending on the culture of that authority.
Yeah.
And I guess that's the big challenge, really, isn't it? Is having that culture being compassionate, empathetic to the different view of the world.
And we're finding that with the consents team as well. We've been able to establish a relationship with them. I worked with them for a long time. So there's a bit of that mutual understanding as well. We've got, I think it's been mentioned in the part 1 Tanga Whenua Section 42A report around secondment. So we've got a member from the planning team who's on secondment with us for part of the week. The conflicts are managed between MPDC and us in that regard. But yeah, just to expose their staff to what it's like in our office.
Yeah, I think I read that, thought that was a pretty insightful way of getting some good communication and knowledge, and sharing of information. So that's going okay. That's a comment.
Yeah, it's been great. Yeah. So Josh just works on the regional council consents that we get coming through as well.
Okay, so you can actually. Right. Was there any other? They haven't been to a question. process.
Not just sort of leapt in there.
Yeah.
Sorry about that. Sorry, Sarah. I had one other thing I wanted to raise. Have you got, I don't know if you've got it there, but Joe's report, paragraph 64, talks about the amendments that come out sought in respect of the Penal chapter to reflect the statutory requirement to engage Tangata Whenua as cultural experts. And I'm just wondering where that statutory requirement comes from. I couldn't see anything. And Joe, can you just help me out? I couldn't see it in the SUD. Is it somewhere else?
I'm not aware that there's a statutory requirement, but that's the nub of the submission that was made.
Yeah.
But it's about this process.
Yeah, okay. And I'm not questioning the substance of it.
Mm.
I mean, I think what you're actually saying is that it's about engaging with Tangata Whenua who are experts of their culture.
Mm.
Because culture is such a big thing. I mean, the anthropological sciences now talk about the broadening discipline of cultural evolution, and to some extent, everyone's an expert in their own culture.
Yeah.
And I know exactly what's intended, and I support it, but I wonder whether the language could be quite a little bit more specific about the nature of the expertise here is very much that Tangata Whenua expertise about it, culture. Te Kauranga Tangata Whenua. And it's just an observation.
I think your speaking notes have answered all of my questions. I think I only had one. It was just a little bit of a clarification just from an earlier conversation about Tangata Whenua engagement. So we've got this tension with no duty to consult resource consents requirements, those requirements, and then good practice to engage with Tangata Whenua to get a full application, have all the information for decision makers. And that's tying to this matter of, we're talking about the GIS system and this planning staff having access to that, and which is most of the staff know what to do, and there was a few that need some training, so it's always an ongoing process. Did you have a level of confidence around that, what you've seen in terms of practitioner of the process of the consent staff implementing the intentions of these systems? And thinking there's a little bit of a gap between what's in the plan and what's not in the plan, and what's not in the plan is some of those practices of the staff, understanding where the information is in the maps and in the plan, and doing that to the level that meets your expectations. So I just wondered if you had any further comments about that, past, present, and future.
Reflecting on the experiences today, there has been some concern around the consistency of the planning team, the consent planning team, but I think there has been, we've noticed that change as well. So not much more to add other than that implementation of once the proposed plan becomes operative, that it's done, I guess, in a way that meets everyone's expectations from the start. Because if you look at the operative district plan now, we're Tangata Whenua, we're one section of the plan, issue 19. So now if you take the direction of the proposed district plan now, we'll be right through that process. So.
Thank you, Martin.
I can't help myself. I mean, it's even more reason to have the plan clear, so to take human elements out of it. So you didn't hear that from me.
Yeah, it's actually recorded.
Two very mechanical questions. On your second page of your speaking notes, item 1, the comments on the Tide Energy and Federated Farmers submissions, were they as a result of further submissions by Te Ahiawa? Did Te Ahiawa lodge further submissions to Tide and Federated Farmers?
Yes.
And back on page 1, paragraph 3, and I know that this is going to be dealt with later on at another hearing, but you did say there needs to be appropriate objective and policy responses to this and definitions. Comment that I've written down is what is that response, and is it specified in the Te Ahiawa submission, and if so, will we hear about it later on?
Yes.
Yes and yes?
Yes and yes.
Thank you. That's all from me.
Thank you, Ms. Marco. Thank you for your assistance. Mr. Holdwich. Next up. You have some evidence before us, Mr. Holdwich.
Indeed, and I have some speakers notes as well.
Thank you very much.
That is circulated.
Thank you.
Chairman, Commissioners, Kia ora koutou. My name is Keith Holswick. From last time, Mrs. Marsh puts in her apologies. She got called away unexpectedly and cannot be here this afternoon. Thank you. I note, Mr. Chairman, that events of this morning has overtaken much of my evidence, my speaking notes in regards to the GIS system. So I think we can skip over that when we get to it. Okay, which it says that this will be dealt with later. So before we commence, I wish to make it very clear that we fully support our relations Ngā Mahanga Ratairi, Ngāti Mutanga and Te Ahiawa in their submissions. We're not opposed to them, we're part of them. We just happen to believe that we need to take care of our own rohi. And that's why we're here. We're looking after our own patch, but fully supporting all those other people. No dispute about that at all. The speaking notes, Mr. Chairman, I've highlighted in appropriate colours matters that we're wording we would like changing. If we can go straight to part 1, tangata whenua, paragraph 5. We have read and understood the reporting officer's report, and we agree with the issues that have been identified. And we support the proposed change of wording regarding the recognition of the hapu groupings and our hapu name being under the umbrella of Te Ahiawa. We agree and support the use of macrons, and we put the various options in red that we would like for our hapu name. If council would be prepared to put that in, it'd be much appreciated.
Helpful, thank you.
And I think, Mr. Chairman, it's important that we recognise and agree with council where appropriate. We're not here just to object, we're here to support as well. Paragraph 6, the Kaupapa Māori framework, we support this section and the recommendations. Dead simple. Number 7, treaty settlement issues. We've previously expressed concerns regarding the council GIS system. We note this morning that these matters will be talked about later on. Just wish to ensure that we can participate in those discussions later on, even if we haven't submitted specifically. It's regarding the use of GIS. And in my previous life as a land surveyor, I was very keen on the use of GIS system. And we know that the matters that we're raising can be fixed in the council GIS system. We know that because we've done that in our own GIS system. So we know it can be done.
And Ms. Evans has confirmed that you do have a role in this, so that's all good.
Thank you very much. And with that said, we can skip section 7A that deals with the GIS system. 7B, we're very pleased to note that council encourages and supports engagements with us as a hapu to help applicants respond to relevant cultural matters. We're extremely pleased to note that council must provide resource consents to us if an activity is within, adjacent to, or directly affecting statutory acknowledgement areas. This has been discussed. We would rather view all consents, even if they were just a list on a council website, so that we could go in once every 2 or 3 days, look at the consents, and pick and choose as we deem fit which ones we need to actually address. So that was discussed this morning, and as I've said in our speakers' notes, we would rather be all consents, but initially statutory acknowledgements, thank you very much, we'll accept those. Item 8, engagement and consultation. Must make the statement that we're happy that council finally now recognises the need to consult with us, and that both parties must act reasonably and make informed decisions. We trust that this recognition will put to bed the unilateral decisions council have made in the past that have unduly and adversely affected our hapu, and that at times have extensively damaged our relationship. We're on a new path, Mr. Chairman. I think we just mentioned that to show what's happened in the past. We're on a new path now, and we're hoping to move forward. Part of that is the council have a list of what they deal with and how they consult with our hapu. And there's one item that we'd like to put in there, and it's regarding cultural capacity discussions. Not quite sure if that's the right word. We met Ms. Tūmarengi Marsh on our first meeting. Yes. She is a cultural expert. She is on the governance board of the EPA panels. Those are the carved panels that came back to Te Atiawa as part of the treaty settlement. She is part of that governance panel, giving her cultural expertise. She works for Puki Ariki in the management committee there, giving her cultural expertise. By mentioning this cultural capacity discussions, we are recognising the work that Tūmarengi does. And I'm just not quite sure whether cultural capacity discussions is the right word, but perhaps with council we can put together correct words to show that that's what we do. Do we need to come up with exact words now, or can we just say that we would like to be recognised for that work?
Just trying to keep my head around where.
That is in the engagement and consultation with tangata whenua.
Okay, so is that responding to Ms. Ritchie's report?
Yes. It's got a list there of it's got a list of the iwi and hapu groupings and how the council consult with each of the hapu groups. So we would just like to add that one extra one there, purely as recognition for the tremendous amount of work that Tūmarengi Marsh does for us.
I think we're best to just wait to hear back from Ms. Ritchie on that.
Yeah, I see that she's nodding her head there. So yes. Thank you. And subject to those minor points, Mr. Chairman, we support fully in principle the officer's recommendations on that tangata whenua.
Thank you.
The part one, and I think in our original submission, we may have got the general miscellaneous matters and the introduction and general provisions mixed up, and I'm still a bit confused this morning when I looked at that. I think we're talking here about the general miscellaneous matters. And in section 9, when we talk about the introduction and description of the district, we support the inclusion of other settlements in the district. That was a big one for us, that the smaller townships were being left out of the district plan description. And they are in there now, so thank you very much. We support that.
So the way Ms. Edwards has worded that, you support that?
Yes.
Okay.
We accept it, yes. We support the kaupapa Māori framework and the hapu and iwi values. We support this section, noting the addition that the tangata whenua cultural values list is not exhaustive. That is, so we support that.
Yes.
The next concern we had, which covers sections 11, 12, 13 in our speakers notes, regards the GIS system. So I think, Mr. Chairman, we can skip straight past those. They will be dealt with at a later date.
Remind me when they will be dealt with, Ms. Edwards.
So there's two parts of that. The first, so to do with functionality of the plan and minutes on sites of significance to Māori.
Yes,
so,
they'll be dealt with there.
It will be in how it zooms out, and when it zooms out, you lose sight of the site. So
yes,
that will be dealt with in the. And it pops up in two places, in the sites of significance to Māori chapter, as well as the general mapping chapter.
Yes.
But I do note that Mr. Holswich has put in something different here relating to the step-by-step guide, which wouldn't be covered by those submissions. So this is a new bit you might wish to talk about.
It's just, Mr. Chairman, the step-by-step guide, the very first note says, check the planning maps to identify the zone, area, overlay and features that applies to your property. The GIS system does not do that. And Ms. Ritchie has explained how some of the statutory acknowledgement areas are not on the GIS system. The GIS system does not allow you to identify sites of significance to Maori if that site is not on a property. If it's on a road reserve, you cannot access that site. And I've listed there on page 4 the items that I think are deficient in the council's GIS system. There's things that I think should be added. And again, in my previous life as a land surveyor, I would say close to 100% of dealings with rural landowners dealt with aerial photographs. They just want to look at the photo. Can you see our house in the corner? Can you see that? If you put the aerial photo on the planning maps, the overlays disappear and all the sites disappear. So if the farmer then says, well, we, as a surveyor, you would not know that there was a site in the corner, it disappears. The overlay should always be on top of the base layer, and that doesn't happen in the GIS system. Happy to sit down and go through with anybody in council how that should work.
So I'm trying to establish, is that being
where is this
considered in another hearing, or do we need to, again, is that a functional thing of the GIS system?
It sounds like it's a functional.
I don't think it's a planning matter. I think it's a technical issue. And there seems to be a difference between what the planners are trying to get and when the technical people who probably sit behind closed doors and never see the light of day, but experts in their field are doing. It just seems to be not quite the gelling going on.
I think there's sort of two ways there. I mean, we're not code writers, we're sort of plan writers.
Yes.
So it's a question of which, is this the tail wagging the dog here? Is it the limitations on the platform that's driving how the words have to work, or is it the other way around, or is it a combination of both? So I think it'd be quite useful at some stage to get a sense of that. Because ultimately this has got to be an E-plan.
Yes.
It's got to work and it's got to achieve what all of the words say it's going to achieve, albeit within the confines of an operating system. Isn't that right?
That GIS front menu is going to be the mainstay of the whole plan.
Oh, yeah.
If you click on a property, you need to see what's on that property. You don't need to zoom right in to see one corner to find our site. You don't want to change the background and the sites disappear. You want to see the statutory acknowledgements. You want to see everything on that page. You don't want to go to side menus. And I think Ms. Ritchie talked about that the other day. We've passed over all of our sites to the council. The only way to access some of those sites is to go through 3 or 4 side menus to find out what they are, instead of just clicking on the site on the plan and someone saying, that is a pass site, stay away from it.
There are pros and cons of that approach to some extent. I mean, if I want to isolate the particular implications of one overlay over a series of properties, it's quite good to be able to turn them on and off. That's a very great technique. Well, I think you can. You do have the ability, if you uncheck the boxes, things go away. So you can very much isolate specific items that way. And I know another feature of the, I always hate to use the word because it seems so far away from me, but they do have an indication on their map, because it's all very GIS based, it's there, that some features are only identifiable at a certain scale. And that's simply a consequence of the limitations of the platform and the number of pixels that you've got on the screen. So, yeah. So I think there's
just needs a bit of a tweak, and I'm quite happy to sit down with anyone and go through this outside this process.
So Ms. Weaver, when you report back, just talk to us about the issue and how you might deal with this. Yes, thank you.
Thank you very much. And I've got there on my item 14 of the speaker's notes that the relief that we seek is that council be directed to do this. I think, sir, you haven't directed council, but it will be done. So that's very good. Paragraph 15, subject to the GIS matter, we support in principle the introduction and general provisions. So we're quite happy with those. And again, we'd like to thank council for that. Not quite sure whether it was the general miscellaneous matters or the introduction and general provisions. We didn't originally submit or further submit to that, so we'll make no comment, but I think we've covered all the points that we've got concerns with at this stage. And we go straight to the conclusions. I believe that the particularly good start to the council plan update process wobbles a bit with this GIS matter. But again, I say that I believe it's a technical rather than planning thing. But that said, we still must congratulate the council reporting officers on the matters they have identified and raised in these part 1 matters. And again, we're not shy in coming forward to say thank you for the work that you're doing. We'll let you know if you don't do the good job, but at this stage you are doing a good job. Mr. Chairman, Commissioners, we look forward to participating further on this plan update. And once again, we thank you very much for taking the time to listen to us. And we shall see you again. Happy to take any questions.
No, I didn't. Thank you.
No, sorry, you're off the hook. So, and again, I'll just say appreciate your assistance, and we'll see you again as well. Thank you very much. So, Mr. White. Yes, we're just taking a brief stop. So if anyone else wants to nip out for a comfort stop.
Yeah. So,
Thank you, Mr. White. The floor is yours.
Afternoon, gentlemen and ladies. Firstly, I'd like to apologise. I haven't read the district plan at all. Mainly because the workload that we're under at the moment is quite substantial. We've got a couple of meetings, well, I have a couple today. So, I go to Rotorua Monday next week for 3 waters issue, we go into a health board, and there's a whole lot of stuff going on. And I make no apologies for not reading the plan, but I have taken an interest in the hearings and have listened with interest to some of the submitters. And I mentioned in my opening sentence that I'd provided an earlier submission. I find out from one of the clerks that was to the long-term plan. So apologies for that. And just sort of.
But did you get what you want?
Sorry?
Did you get what you want?
Well, I'm not. I think that's sort of making. And just a typo. 2/3 of the way down the page, I talk about authorities that predate the sea change that I referred to earlier. And post date was the.
So what paragraph is this, Mr.
What were we? 1, 2, 3, 6 down. Starts with during Mr. Mount's presentation. The second line I've got that predates it.
It's changed to post date.
Yeah.
Thank you.
But what I would be rather keen on is I don't walk through my submission with you. I'd like to be able to answer some of the material information that was shared this morning. Is that possible? I know this is not adversarial.
You're a further submitter on the Putama.
Yes.
So you're able to talk to us about that.
Okie dokie. But before I do that, I was also interested in listening to the surveyor's concerns this morning, and I couldn't help but thinking that some of the tangata whenua issues, mana whenua issues, hapu identifications and the like, come from the early surveys where maps were drawn, names were put on maps, and history seems to have been frozen in that time, and we still live with some of that stuff today, and it's probably helpful, but it has its drawbacks as well. But it was interesting to see how the some of the issues that they raised, and I haven't heard it raised in Ms. Marple's submission, but I would have thought that waterways or water bodies that have been filled in or closed over would have had a cultural significance to the local hapu because of the way that we resided back or settled the area back in the day, where streams were often the boundaries between whānau and whatnot, and the mere fact that they've been covered over doesn't mean to say that they have got a significant cultural impact on most people that lived near to those streams. And I'm not sure whether it's answering anything, but it just was an interest that sort of flicked over in my mind. Now, yes, we did that. So. Okay, and I'll go on to the submission made by Mr. Gibbs and my cousin Rodney, home one, sorry. To start with, Mr. Gibbs in another forum has admitted or confessed or declared that he is he's not Māori, he's definitely not Ngāti Tama, and he doesn't fit into that tangata whenua or mana whenua space at all. And to have both Mr. Gibbs and his sister explain who Ngāti Tama is, or where the rohe is, or even our history, is difficult to sit through. However, that's the nature of the beast that we're dealing with. I handed up 2 additional judgments that came out on the 15th of July and the 9th of July. So they're recent judgments, and in both of those decisions, the 15th of July decision comes out of the Supreme Court. It confirms the appeals and the decisions of the High Court and the Environment Court decisions to not recognise Potama as tangata whenua or mana whenua.
In relation to the Mount Messenger project.
Well, I didn't bother with that because I know that you have, sorry, did I hear the question properly?
No, I think that this judgment was in relation to the Mount Messenger.
Sorry, yes,
designation.
yes.
This is a very recent decision
Yes.
of the Supreme Court.
Yeah. And I only handed the second judgment up as a result of Mr. Gibbs telling the court for the hearing today that they've got some specific relationships with third parties, or in this case, First Gas, and that sort of quite clearly defines what that relationship is, and the interim injunction was granted.
Are you saying Mr. Gibbs said he has relationships with some of the petrochemical companies?
Judgment talks about now, and I think it's clause 13 in the 2nd July one. As the bypass does not lie within the existing condition. Yeah, the third line, First Gas makes annual payments to the Gibbs Family Trust. In addition, First Gas claims to have paid compensation. Right, so that's the.
So what's the point you're trying to make here?
Okay. Mr. Gibbs prevented First Gas from going on to his property to repair a damaged gas line, and First Gas had to seek an injunction to provide them access, and so that they were granted that injunction. Mr. Gibbs this morning was trying to confine his the judgment from the Environment Court to the Mount Messenger project only. This expands it through into his property.
This is some other litigation associated with his own
totally separate
property.
Yeah.
Okay.
Yes. So to get back to my opinion on the difference between tangata whenua and mana whenua is quite simple, and my understanding. Commissioner Coffin comes over here, he is tangata whenua, obviously we know that, but he doesn't hold mana whenua status in Taranaki. I would have to say. Well, it gets even more interesting. And I think if you go to the judgment of that Mercury Energy judgment recently regarding the Mangakino project, are you aware of the judgment? I think it was Cook.
Okay.
Robin Cook's son. I can't think of his name.
Was it a High
Francis Cook? High Court decision, yeah. And the background to that was the Crown ran out of land to grant to Ngāti Kahungunu during the the early days. So they granted land in Mangakino to Kahungunu, and the local mana whenua were looking to stake their claim in their own rohe, and that's what the judgment sort of focuses on. It's about the difference between mana whenua and tangata whenua.
Okay.
And Māori from tangata whenua from another rohe coming into your rohe, have, I think it's wording was something like they have no greater rights than Pākehā. In the case of Taranaki, we have some iwi that visit here that I argue have got less status than Pākehā, only because of the historical arguments that we've had over the years. And I'm not sure whether that answers the difference or the issue, the difference between mana whenua and tangata whenua, whether it's in the plan or not. I don't see how you could avoid the term mana whenua, but that's up to each of the particular iwi grouping.
Certainly I'm aware of those Mangakino lands because there's lots of very large dairy farms all over those. And there's, so I will have a look at the Justice Cook's.
Yes, it's against the tribunal. I think the energy, was it nuclear energy or nuclear energy versus the tribunal? The tribunal wouldn't use their resumptive powers. I'm not sure that, can't recall the basis of the claim, but it was the tribunal found that you couldn't the tribunal was correct and no, I'm going to hear it. I've forgotten, and I'll let you have a look at that out there.
I suppose I'm interested as a practitioner, certainly in Hawke's Bay, Ngāti Kahungunu and the hapu in Hawke's Bay prefer to be called mana whenua hapu. That's identifying them that they are mana whenua, whereas to be tangata whenua is as you've explained it. But it seems like it's pretty settled through the submissions and the way the plan's organised to certainly have a tangata whenua chapter. The National Planning Standards, it gives the council and others the option of using terminologies. As long as it doesn't offend anyone, the right nouns and verbs are used where they're appropriate. That's the key thing, I think.
Yes, and just a minor issue. Mr. Gibbs referred to the tribunal, the recent tribunal report that was released last year.
Yes.
And how Potama's claim was well founded. I'll leave it to you to read, but from my reading of that same report, saying that the argument put fell into the category of a well-founded claim, but not necessarily the claimant group. So it was the substance of the claim that was well-founded, not Potama themselves being an appropriate body to run it. We've been engaged with Te Arawhiti for a number of years now, and when I've asked them that similar question regarding their recognition or not of Potama, their response is that they were of the view that the current grouping using that title would never be able to get the mandate of Potama, because Potama is a Tainui ancestor that sort of, if there is a zillion of us at the moment, we all descend from Potama. We've got that problem. To have not only a non-Māori, but a Māori Pākehā that wants to challenge you using the name is inappropriate, but it's just an abuse of a process that I think the Commission is
I think we've been pointed to 2 or 3 sentences and it seemed like a very large report, so we're going to have to read the report in its entirety.
That's fine. But I'm conscious of your time and everyone else's time. I'm happy to just take questions if you've got any, but that's fine.
I think we will move to questions.
I've got nothing specific. Thank you for that. Thank you for those recent decisions. They very much are hot off the press, aren't they?
Well, I'm surprised they didn't hand them up. I'm not surprised.
I think there's a question in what I'm going to say. Firstly, thank you for providing this. I think our role as decision makers is going to be discerning what information is helpful to our task, which is the district plan, and those tasks that are better left to other entities that are more suited and have the capability capacity to determine. So, and I just wondered whether you had any advice in that regards to those matters that you think we should focus on, and those that we should leave well alone.
Also, it's just sort of showing the direction of the rabbit hole. But, no, I think that we support the way that the District Council have engaged with us. As I say, I'm extremely busy and don't participate. The sea change from what it used to be to what it is today is just, well, you just can't describe it. You know, my cousin mentioned how he came in and had engagements with Claire Stewart. Well, I'm not quite sure who he was representing in those days, but it certainly wasn't Potama because they hadn't established at that stage. So it was anyway, you know, we've been here and we had one experience that was absolutely offensive, and I don't think I should waste your time on that, but it's the way that the council used the road stopping rules that are existent, and our paper road that had a berth in the Raupatu that was able to be transferred out of council ownership into the farms. I'm not sure that the plan covers that, but it's a
make sure the Public Works Act and the Local Government Act savings provisions.
Yes.
Yeah.
So, Mr. White, I don't have any other questions apart from a comment that as a panel, just so everyone understands, the panel, we have provided people the opportunity who are submitters for us to go on a site visit if they request. So we've been requested by Mr. Gibbs' team, and we can't resist that. That's their right to ask, and our procedures say we could go. There are very strict rules, as I said, about how we deal with that, and I wanted to get it just for the understanding. Clearly wanted to get an idea of the land under the ownership, control, management of Potama has represented the group that came today, and that will inform us in terms of some further knowledge. I have, in the previous case we've talked about, which I'm not sitting on, myself visited those general lands, as you know. I do have the geography, but I think we'll have to follow the course with that request for a site visit.
That's certainly your prerogative, but I wasn't asked for advice when Land Information New Zealand were requested to go up and visit. I provided that advice, and the afternoon of their visit, I got a call saying, telling me that they wish they had listened to my advice. They spent 5 hours talking to kids. Good luck on your visit.
Thank you for that advice. Right, thank you very much, Mr. White, and appreciate the time we take. It's a busy old time, isn't it? Yeah. All right. So look, Ms. Rack has been waiting very patiently on the Zoom, and hopefully you've been able to do a few other things on the way, but it's now the turn for Transpower New Zealand Limited. And Ms. Eng, do you want to say something in advance, or should we go straight to Ms. Rack?
Apologies, Mr. Chair, my computer was a bit slow to react. No, I don't have anything else to add. Ms. Rack can go straight ahead. I'm here out of respect for the process and to observe. Thank you.
Appreciate that. Thank you very much. Is this the same? Summary. Summary. Okay, very good.
This is the summary.
Oh, okay.
So firstly, I'd just like to say thank you for accommodating us. It seems like I should have taken a leaf out of Commissioner Littlejohn's book and come down the night before, but Air New Zealand cancelled my flights this morning, so thank you for facilitating this.
Just before you start, I'll let you know that I had to drive down from Auckland, where I was trying to get home, to Napier. In the meantime, I've got a whole new wardrobe because I haven't been home. So yeah. It's been a rough all weekend everywhere, I think.
Yeah, indeed. So thank you. What I've provided was the summary that I would have handed out had I been there in person. So with your indulgence, I will go through it. I apologise because it does seem larger than my primary evidence. The reason for this is because I've provided some examples which I thought would be helpful to illustrate. And I've also been listening, I think it was very useful to listen to your dialogue this morning because it's picked up some issues which I will be talking to. And so these examples hopefully should illustrate some of the issues that you're already alive to.
Thank you very much.
So coming on down to what I guess the focus of the summary is those areas where I've disagreed with the Section 42A recommendation. I know that time is short for you guys. You've got an awful lot of reading, so I just thought we'll keep it succinct. So the first issue is the default or catch-all activity status. So Transpower's submission sought to add a statement to make it clear that if an activity is not listed in the plan, it's deemed to be a permitted activity. The Section 42 author considered that this matter was already covered in the general approach section, but I do not consider that the statement in this section to be clear for all plan users to understand, and therefore prefer the straightforward explanation sought in Transpower's submission. And I note that this is fairly common throughout most district plans, and so I've set out how it could be worded just to make it crystal clear. I think moving on down to paragraph 3, there are a couple of options where that is located. It could be in each of the chapters, or it could be in one central location, which is obviously more efficient. Either way, I do support the approach of a default catch-all permitted activity status for activities not listed, which from what the Section 42A report said, that seems to have been the premise under which the district plan has been drafted, and I'd certainly support that. Moving on down to the next one, then activity status that applies where an activity covers more than one rule. So in paragraph 4, Transpower submission sought inclusion of a statement to clarify the activity status where an activity is covered by more than one rule. So the Section 42A report recommended this to be deferred to the Network Utilities chapter. However, the thing is that this issue is not unique to network utilities, and I heard your comments earlier this morning about that. It is a particular problem with the network utilities, but it's certainly a problem actually across the board. At paragraph 5, the section 42A author seemed to slightly misunderstand the submission point and recommended rejecting the submission on the basis that it's entirely appropriate to consider the effects of an activity that trigger multiple rules. But the submission point was actually seeking to clarify where an activity was covered by at least two rules, as you'll see shortly, are located in different parts of the plan, which is, I have to say, an unfortunate consequence of the national planning standards. And so I've suggested an amendment which could clarify that situation. And going on down to the next pages, I've actually put some examples for you. Now, Commissioner McMahon earlier this morning asked about where an activity was addressed in the district-wide and again in an overlay. And Commissioner Littlejohn talked about the unitary plan, Auckland unitary plan, situation, same problem. Yes, it does happen. It happens in this plan. Interestingly, it happens within a chapter and it happens both across chapters, as you'll see here. So on my page 4, these are just snapshots straight out of the district plan, the proposed district plan that is. And this is in the natural hazards chapter. So within this chapter, you're actually seeing duplication. So the first one is below ground network utilities, associated earthworks, vegetation disturbance. And then the next one down is alterations to a building or structure. And then the next one down at R11 is your network utilities, including upgrading and existing network utilities. Now, potentially, given that a structure is something that's attached to the ground in terms of national planning standards, your works could actually be covered under all 3 rules. And as you can see, they've got quite different activity statuses as well. And moving on down to the next page, at page 5, a similar. These are just examples. I mean, there is a whole truckload which will become apparent to you as you go through the hearings, I'm sure, but they're just to give you a flavour for what the problem is. The next one is within the notable tree chapter. You've got earthworks, that's rule 3, earthworks within the root protection area of a scheduled notable tree. And then at rule 8, you've got underground network utilities and infrastructure within the root protection area. Again, a single activity potentially covered by 2 rules. And so these ones are going to be difficult to sort. And so what I'm saying is maybe a better way is just to make it clear that where you've got an activity that could potentially fall under both of those or either of those rules, just make it clear which one prevails. The one that's more specific is the most important one. Now, I've also, that was, as I said, that was within a chapter, but while the hearing's been proceeding today, I've actually found some that are across chapters as well. And I'll have a go at the screen.
Before we carry on, and just to look into this interpolate. So on your suggestion, those 2 examples, which would clearly be the most specific rule in your example?
Taking the notable tree one as an infrastructure provider, even though it's probably not helpful because it's a restricted discretionary activity, I would find myself attracted to rule 8 because to me that's more specific than rule 3, which isn't.
So if Transpower was putting a structure on the ground, a pylon or a pole or something, you would say that the more specific is for the notable trees would be R8. That would be your interpretation.
Yeah.
Could others have another interpretation, do you think?
Probably, and I think this is, I can see us having conversations forever about interpretation going forward. I think this just shows how it is open to interpretation. I mean, I could come along and say, well, actually, I could comply with the standards in R3. So even though I'm a network utility operator, therefore I think R3 should apply. And arguably the council could say, oh, hang on a sec, you're a network utility. Actually, sorry, R8 applies.
Or you could argue section 1042 and say the plan permits earthworks within the root protection zone of a scheduled notable tree. Therefore, I can disregard those effects when considering when I'm doing it for the purposes of a network utility operator. So end up going nowhere.
Yeah, I can see some real implementation problems.
Lots of work for lawyers.
Yeah, I'd say it's probably more Commissioner Littlejohn arguing for a squad rather than. Yeah.
I suppose the other way, I mean, the other option is the unitary plan one that you put in there, which I guess is also, we've got a question of scope around that. But if the way that rule operates in practice is that it's where you've got the same rule that has different stati, so to speak. You take the worst scenario anyway, so you'd end up in that scenario, if you were a network utility, you'd be restricted discretionary regardless.
Yep. Yeah, agreed. And I will get to your scope issue because it is as a consequence of this other issue. If I can screen share, I'll see whether it will allow me. Looking good so far. Okay, so this is across chapters. So the other two examples that I had were within a single chapter, and you could clearly see the issue there. Here, this is across chapters. So this is NU is the Network Utilities chapter. And here you've got operation, maintenance, repair or removal of above and underground network utilities and ancillary vehicle access tracks. Then going on down, still within network utilities, R4, you've got vehicle access tracks for network utilities. So you've got clear duplication there. And then if you go down to the earthworks chapter, you've got earthworks for network utilities, including vehicle access tracks for network utilities. This one, a little bit of a saving grace is this here. It does reference EWR9, but again, you can clearly see same activity covered by in multiple ways. So exactly the same thing. And then just another one as well. So it's not all about network utilities. I was listening to Commissioner Littlejohn about the resident, say the residential zones or industrial zones or whatever against an overlay, and exactly the same things happen here in general residential zone. You've got relocation of a building, and then also in your natural hazards, which is an overlay chapter, you've got relocation of a building into a hazard area. I think as a practitioner, I would go to logically this one here because it's in an overlay, but I think it would be useful to have it clarified. Because to my mind, the one in the overlay would trump the one in the general. But again, it needs to be sorted.
Where
Okay.
in terms of your statement on page 6?
Yes, going back to page 6. So this has raised as a consequential issue, and I noticed your comments about scope with regards to the activity status and the bundling of activities, because figuring out when you've got a particular activity with either a duplication of rules or a bundling a single activity with multiple bits to it, this is how this issue arises. So this was sorted by the Auckland Unitary Plan. They included guidance, and I've considered something along the same lines could be quite useful. Basically, this one down here is probably the key one. The overall activity status of a proposal is that of the most restrictive rule which applies to the proposal. It seems to be where case law is going, and seems to be quite a lot of case law saying that's the most appropriate approach.
It's more than going, isn't it clear?
Yes.
By case law?
I think so.
Okay.
And Ms. Reid, you're saying that that's a consequential adjustment arising from your original submission?
Correct, yes.
And that provides scope in your view?
Correct, yes it does. Going on down to paragraph 7, inconsistencies within and between chapters and gaps in chapters. Transpower supported a submission from Heritage New Zealand, which sought to amend the plan to remove inconsistencies within and between chapters and gaps in chapters. The Section 42A author recommended deferring this matter to the historic heritage, earthworks and subdivision hearings. But I just wanted to make the point that, you know, you're all very experienced commissioners. This submission and the scope provided by it could be very useful in the future to fix up anything that you come across. It may not be specific scope for, but you can clearly see as a problem. Going on down to paragraph 8. So when reviewing the proposed district plan, it was often not clear what the activity status was. I found the colours were confusing, and the absence of an explicit activity status could be interpreted to mean that no consent is required. And similarly, the green colour for controlled activities may imply to plan users that the activity is permitted. The Section 42A author recommended rejecting these submissions and explained the challenges of working with software which is focused on submission management rather than how rules appear. So I do support, and I understand that, but I do support using a specific and unique colour for each activity status, but I'm also aware that some users of the plan are colourblind, and believe it or not, I've actually worked with a number of GIS people who are colourblind, which makes some of their colour choices pretty interesting, but it's not uncommon. While the Section 42A report author supports activities with similar activity status being grouped together, I consider this may cause confusion for users of the plan and prefer each activity being separated with their own clear activity status, standards and activity cascade where standards are not complied with, because this will make interpretation of the plan clearer. The presentation of rules in the notified version may have led to submissions either being lodged or not due to lack of clarity. And I've got some key examples, and I have to confess that when we put this submission together, 2 planners looking at this with over 50 years experience, we embarrassingly looked at some of the activities and thought that there were no standards because they're separated. Now here's just some examples, again, network utilities, because that was easy to grab. But I think the actual network utilities rule 7, 8 and 9, I suspect that they all have the same activity status. And yet when you look at them as they are now, you would think that they're 3 separate rules and there are actually no activities, you know, apart from permitted, no standards, which go with rule 7 or 8. And I understand that going forward, the idea is that these will be mushed together without any white between them, but I'm really worried about what that means for your submission process.
Is that a technical planning term, mush?
Mush.
Absolutely.
I must say, I
mushed together.
I implied the opposite, that that I couldn't conceive of a situation where a rule wouldn't have standards. So I just assumed that they must have all applied, but that's just, I'm probably a pessimist rather than an optimist.
Yeah, maybe I was looking at the glass half full.
It illustrates your point that.
Yeah. And same thing, next one down. I'm pretty sure this is the sites and areas of significance to Māori. I'm pretty sure same thing, that the standards down here actually apply to rule 2 as well as rule 3. And I think the other, and I know that you can't fix this at the moment, but I do think, especially with these rules that have immediate legal effect, this is a real problem for council. I can see there's going to be a lot of arguments about it. And I think it's just something to be aware of in the final decision. If we can fix it, make it clearer, then I would recommend that you take that option. And same thing here, 25 and rule 25 and 26. So I'm looking at it now with fresh eyes and having had the benefit of what the Section 42A explained, pretty sure those standards apply together, and same with 27, 28, but that's certainly not how I read it to begin with. And just another one as well. This one I found very confusing because the grey, again, the importance of colour. When I started looking through the plan, I got green made sense to me to be permitted. Suddenly you throw in grey and I had no idea what that meant.
Ms. Reid, just on the colours, is that determined by the National Planning Standards? Is there any scope to depart from those? 2 questions there.
I'm not sure. I think, yes, it is prescribed. I think the implementation might have got a little wayward in the proposed district plan. but maybe there is some relevance of grey. I'm really not certain.
Are you concerned with control being green because you see green for go? Is that the
Pretty much. Very simplistic.
okay? That's my contribution to the planning geek.
And going, sorry.
Yeah. So Ms. Rat, is that the end of your?
No, there's just one more small issue that I'd just like to raise, and that's the use of and or in paragraph 9. And the section 42, I think recommended except in part, but again, I would encourage the panel to be aware of it, particularly with policies, not so much in objectives, the way that the objectives in this particular plan have been written, but as you know, the use of conjunctives can completely change an objective policy or standard, and I certainly support the panel being aware of this and using this scope where necessary.
Are you saying that the rules, or the wording should be either a conjunctive or disjunctive, not both?
Yeah, I think being just very aware of when it's an and or when it's an or, and making it super clear.
Because presumably there's no need to have and/or if it.
No, I think it's one or the other, but being clear about which one's appropriate.
Yes.
So just to be 100% sure, so the plan does use and/or in some places?
I don't think so.
Okay. You have seen it?
I think I have seen a couple.
And so you say, need to look out for that. The word is nodding. It's yeah. So we'll just it's a key sort of drafting matter.
Yes.
There was got a turn on the site, so do the old search all maybe we can move on with that. So thank you, Ms. Ratt. I'll just if there's any questions, I don't have any.
Yeah, I just wanted to talk to you about item 1 that you had around this catch-all rule, because I mean, the default position is really section 9(3) of the Act, isn't it? That unless you contravene a rule, then you can do it. So actually classifying every activity that doesn't contravene a rule as a permitted activity, does that bring in a whole lot of other stuff, like standards that might apply to permitted activities generally, that you then by default apply to activities that you never sort of contemplated to arise subsequently?
Yeah, I take your point. I've seen a lot of plans do it differently. Some have a non-compliant because they just worried that there's something that they've missed. Others have a discretionary because they think that that's a little bit less. And then you've got others which are pretty sure that they've captured all the important activities and anything minor is fine. I think for clarity, I do prefer the permitted status. And I think it's hard to know where our acts are going to go, but I think inserting something that was super clear, there's no risk. And especially one thing that's come up in terms of the Waikato district plan, actually, bizarrely enough, is little things like letterboxes and clotheslines. Sounds bizarre, and you're like, why would you even need a rule for that? But because that particular plan has discretionary as its catch-all, they get caught by it, and suddenly that's changed because of the definition of buildings and structures that are in the National Planning Standards, which covers absolutely everything that either has a roof in the case of a building or is attached to the ground in terms of structures.
So a letterbox has a roof and is attached to the ground, is that right? It's a structure.
Yeah, bizarrely, and so it becomes a discretionary activity. So we're fixing it. Yeah, it is just a nonsense.
So I am 100% sure that you finished.
Yeah, no, that's just.
I'm 100% sure Commissioner McMahon has some questions. So
it's not for me to disappoint. So, look, I'm going to take a bit of evidence in chief, Ms. Ratt.
Yep.
So just a few clarifications more than anything on this.
Hang on, just give me 2 seconds, I'll bring it up. Got it.
Okay. So at paragraph 13, 14, 15.
Yep.
Simple fix that you identified in the original submission at the end of paragraph 13. You're saying now that that would be better replaced by the Auckland Unitary Plan wording.
I think it's two things. You've got two issues here, and they are very much related. So you've got an activity that's covered by a duplication of rules, which I think that the National Planning Standards, from what I've seen and all the other ones I've looked at, does lead to that, unfortunately. So I think that addresses that issue, the duplication in multiple places, like the relocation of a building that we saw in the zone chapter, as well as like the natural hazards chapter. The second one is the bundling of activities. And I think it's going to be an issue for network utilities where you've got a whole lot of different bits associated with a single activity. And so that's the bundling. So I think there are two different issues.
Yeah, so they're not alternatives, they're
complementary. Yeah.
And where would you see those located in the general section of the plan?
Probably, if for efficiency, a central location would make sense, yes. Then you've just got it once.
Would it need to duplicate it in each chapter?
Yeah, great.
Okay, covered the scope issue review. The question was, in your summary statement where you've given some examples of duplication between within zones and between zones and between zones and overlays.
You're seeing it in all of them. So within a chapter, across a chapter, across district, between two district-wide chapters, and between a zone and a district-wide chapter. So you're seeing it in all of them.
Okay, and within that conversation, the idea, or your confusion that because the standards weren't immediately under a rule, but were 2 down or 3 down, you weren't sure whether they were part of the rule or not.
Yes.
Did you happen to see Ms. Johnson's various iterations this morning where she provided different ways of slicing and dicing the
No,
rules?
I haven't. No, I didn't say that.
Okay.
You have to make your own call without help from Ms. Rat.
Okay. I don't know that I can ask you a question there, therefore, other than to say that she provided an example of a subdivision chapter, and also then she focused on the residential zone. She had 3 iterations of how that might be produced if her submission was successful.
Okay.
You may or may want to look at those, but I don't know whether I can ask you a question on them.
That's a lucky escape.
Okay. I think that's probably the end of our questioning. I'd just like to say to Ms. Ng and yourself, Ms. Rat, certainly appreciated the supplementary table with the relief given to us last Friday. That was very helpful, and certainly the submissions from Ms. McIndoe on the legal questions. We gave everyone else a bit more time, but obviously that was done. So just appreciate transparent participating in those requests. So thank you very much.
Thank you, sir.
So,
can I just ask a question while I've got?
Of course you can. Yes. So Commissioner Littlejohn's coming back.
Uh-oh.
And I'm going to accept you know a whole lot more about the contents of the bottom bit of the plan at this point in time. Just looking, and you just tweet when you're talking about conflicts between 2 district-wide levels. Are you aware of any instances where there are specific rules that relate to network utilities in part 3 of the plan, the area-specific zones and things like that? Or are the activities network utilities all provided for, including earthworks and natural resources, are they all dealt with within part 2, the district-wide matters?
I have to go off memory, because I can't have a look that quickly, but I don't think I put in a submission much on those zones, so that leads me to think it would be in the district-wide one. And one of the issues for Transpower is, and this again comes back to how you slice and dice the national planning standards. You have got a network utilities chapter, but then as you saw, you're also seeing rules around network utilities and earthworks, historic heritage, notable trees, all the district-wide chapters as well. So I think their intention was to have everything together, but that's not how it's been delivered.
I guess that's where you've got district-wide matters that are all sort of on the same par in terms of their importance to some extent, all each vying for slightly more attention based on whether they've got a national policy statement that supports them or Section 6 to refer to of the Act.
That's exactly right, and that's actually something we're struggling with Waikato as well. Which one takes precedence? If you've got signs on a historic heritage place, does that rule go into signs or does it go into historic heritage? And that in that instance, we've gone for, if it's a Section 6 matter, then it's home.
Yeah. Or you've got a subsection that's been listed as a heritage building that you need to replace, and those sorts of conflicts. Yeah. No, thanks.
So when you say we, the royal we in Waikato, who are you working with there?
So Adam Jelly from Becker and I've been working closely to rehome what was and this one's particularly complex because it wasn't notified under the national planning standards. It was translated to the national planning standards after all the submissions and everything, and our decision will be under the national planning standards.
So you're working with the council on that?
I am, yes.
Okay. Right, I think that's enough for Transpower. Thank you very much again. Ms. Edwards, Commissioner McMahon and I, we're due for a site visit at 3:30. An arrangement will be made. We certainly do want to hear back from you, Ms. Ritchie, verbally. So I think, and I don't want to constrain you, so I think we get straight into that. We don't take a break. Sure. And take us through the floor yours. Let us know how you'd like to respond.
Thank you. I think we'll start with Ms. Johnson, Helen Johnson, who for first this morning. The 42A report recognises that some chapters include cross references to other relevant district plan provisions, whilst others do not. I recommended rejecting Ms. Johnson's request to make cross-referencing more explicit, because in some chapters, for example, noise, that applies to all zones as specific activities across the district. And I did not think it was necessary to list all the other chapters' provisions, noting that the zones and district-wide chapters contain cross-referencing. In paragraph 21 of Ms. Johnson's evidence in chief, she's looked at it in a slightly different way than what I did, in that she had looked at it from the fact that she thought the district-wide matter should actually cross-reference back to the zones. That hasn't been done. And she says, she suggests a new sentence to this effect. While I still maintain that the zones and district-wide chapters contain adequate cross-referencing back to the relevant chapter, I do consider there is some merit in widening this approach to apply cross-referencing of district-wide matters back to the zones. And I agree with Ms. Johnson that this matter could be addressed through the 42A reports for the relevant chapters here. And that was her recommendation and her evidence in chief. So I suggest that we could look to make a change in recommendation in that regard, and then as we step through the relevant zone chapters, through the relevant district-wide matters, that they actually check whether that cross-references back to the zones. Not forgetting the zones already do that, back to the relevant district-wide matters, but we haven't got it going the other way.
Yes, okay. Yes.
So, and it would be a case of, again, putting that as a consequential amendment, and that would have to be tracked, and the relevant reporting officer, as they went through on those district-wide matters, say whether the statement has gone in and whether that can be amended.
So just thinking with that approach coming out with other hearings, is that something we should be recommending or suggesting somehow? Because otherwise it's, we don't know what our thinking is.
Yeah, that's right. We've got a slight, that's right. We haven't got the recommendation out of you, but what I could do is verbally tell those planning officers now that I recommend this is the way going forward, noting that it hasn't been agreed by the hearing panel in any way. That would be one way of doing it. The first lot of those reports coming up to the district-wide matters is due this week.
Friday.
Yeah, so we'd have to shift pretty quickly if that was the case. But I don't see the change as requiring a great deal of analysis. It's a simple check of the cross-referencing to see whether those district-wide matters actually go back to the zones themselves.
I'm thinking that if you're taking the suggestions from Ms. Johnson, and that's from an overall plan point of view, thinking it's helpful for plan users and referencing, can you make that a recommendation, change the recommendation or reply, make it very clear. In the interim, if as district plan lead, you'd like to get the other report writers to use that and explain that in their reports, I wouldn't have any problem with that. I see it as a helpful thing.
Yeah.
And any other concerns with that? No. Okay. Thank you.
So turning to the plan structure versus the rules versus standards. What I had done is made recommendations to the general approach step-by-step diagram, which Ms. Johnson accepted in part, but what I didn't appreciate that she was actually suggesting full restructure of the district plan. So what she took us through this morning. So we did a lot of the structures that Ms. Johnson discussed this morning. We did actually go through in quite some detail, months and months of working through the different types of structure, slicing and dicing. That's what we've had the two views today. So this is in between when the draft paper-based district plan came out in October 2016, leading into the digital draft district plan, which was in February 2018. So there was a lot of testing. So we did different scenarios where you might have all the relevant effect standard directly under the rule. And what we found was that was quite complicated to make sure we caught all the various instances across all those district-wide matters. But what you do see in the plan is there are some of those still, I guess, attached to that rule where we know that those effects are exactly what we're wanting to manage. So an example would be, there is, I think it's an energy rule where we talk about solar panels on roofs. We know what those effects are, so they're directly tied to that rule, and it's quite discreet there. But I take the point of what Ms. Johnson was saying, that it is consistent across the plan. Sometimes the rules do have these triggers that do appear to look like standards within themselves, and then others sit down the bottom. All I can say is that we thought long and hard about whether something is a rule and whether it is an effect standard. It's very difficult to sometimes separate them, and care has been taken to do that. I do acknowledge that sometimes this isn't perfect. So while I acknowledge the point Ms. Johnson has made, we would really need to undertake full analysis. That would require quite a bit of analysis to see whether some of her structures would work, knowing we've been through a lot of this already, and and the implications of such a change if they were accepted. But so I'm sitting on the fence on that. I really need to take this time to come back with.
When you do your reply, when you do that, I think, could you please turn your mind to any unintended consequences that if you do, it's so some of them when you get down to the 2B one looks like it could be a major rewrite.
Yeah.
What might that mean for our hearing processes in terms of submissions and further submissions and scheduling and tracking scope? And again, thinking about if there was something that you would like to sort of pick up on, whether there's any further notification we need to do or work for the hearing administrators, or I'm not sure. I'd like you to think very broadly, including, might this put the whole process in jeopardy if we did change things too significantly?
Yes. My gut feeling is that we are quite some way down into the process and it would be a difficult ship to turn around, but I just need some time to really understand those consequences and perhaps draw on those different tests we did from those years ago that I talked about and how that looked then and what we worked through. I mean, this was 6 months worth of working and testing and conversations with MFE as well as to how things could work. So, yeah.
So certainly from my point of view, the fact that you've got an open mind to go back and have a look, Ms Johnson had thought about it reasonably deeply, and just respecting that practitioner suggestion and looking at it and coming back to us. Do you think if you did come back to us with anything substantial or significant to improve the plan, we would need to make any guidance about that for future hearings? Can you also think about that, because that will impact on future reports? And have a very broad think about the implications of the suggestions and come back to us with your recommendations would be.
Also need to look at the national planning standards as well.
Yeah, I mean, there are some key directions in there which do require you to have the matters for control and discretion associated with the raw status itself. So,
okay.
So moving on to Mr. Sol and Mr. Dickey. I just simply do not accept that an adequate consultation has been taken, or that indeed it was taken. From my perspective and certainly my team's perspective, this has certainly not been the case, and the consultation we have undertaken with the Institute of Surveyors has been meaningful. As we heard today, we've started from a base of using the operative district plan through really showing a different way of planning, how the plan was going to go. So initially, the very first meeting we did with them was indicating that strategic change we were making through, much like the points that I raised with my presentation on the first day. Those were the steps that we took through each time we met with with the Institute of Surveyors. The 3 targeted meetings that were held were reasonably well attended. I also note at that time that we had survey on those 2 draft plans, so the paper-based draft plan and the digital draft plan, we did have surveying firms submit at that time. So some surveying firms did get involved, including LandPro, which is, who we're not in the room today, but also Landon Jackson, who we did see today, who were some of the members of that institute.
Mr. Dickey is from LandPro.
Yeah, but I don't think, in fairness to Mr. Dickey, I don't think he was working for LandPro at that time.
No, he was there appearing for the survey.
Different roles. So,
different
roles. Yes. So we did have those, some firms, not all of them, participate in those consultation exercises and providing with written feedback. I just want to point out some of the work that we did. Again, just to stress that 8,000 letters were sent to people with their changes in their property, and they were invited to meet with a planner one-on-one to discuss those changes. We had 2 social media campaigns, and you heard about some of those large stats, the people that we tried to reach. They were also targeted at different types of user groups. So, for example, business groups know where to do business. know where to do, know where we're growing, know where we want, know where you need to shop, all of those different things that were targeted through algorithms and things like that, through our, so using the social media to try and target those people. We had 7 master plan days, and we held 127 individuals who did reach out for us and ask for those rules to be explained to them. And as we said, during the submission period, we had 17,000 people visit the website. So I've been involved in a lot of discussions with various groups of people, including a lot of the surveyors' clients. So we had a lot of people contacting us saying, hey, I'd like to rezone my property. How do I go about it? Often interlinked with that is a surveying component, and there'll be often a survey associated in the background of it. And indeed, we've got lots of surveyors who you will see coming through the process who have submitted on a rezoning matter on behalf of a client, or will come along and be represented, helping their clients with their submission process. In terms of pre-application meetings, I've been in lots and lots of discussions, particularly on pre-applications where the draft and proposed rules have been discussed, everything from water body setbacks, multi-unit developments, urban design guidance and structural plans have been common themes with going to those pre-application meetings. And that's just me. There's others in my team who will be attending those other meetings as well. And of course, our resource consensus planners continue to have those conversations daily. Most of the rules identified in the evidence were in the public realm for 19 months prior to notification in the PDP. So there was opportunity to come and talk to us about it. There were some surprises, and some of those rules were different, and that is a case, that's simply a case of further research and refinements through that draft consultation process as well. We also had the introduction of national planning standards that came in there as well. I emphasise that the recommendation to strike out is only on that particular submission point to oppose the whole plan. Other submission points will be heard from Mr. Sol still remain live, and he has made submissions particularly on those residential provisions to do with upzoning or downzoning, also to do with some of those bugbear rules that he has opposition to. They're really valuable, and they will be all part of the consideration on those chapters as we go forward.
So just on the, I think it'd be useful to just write up in the reply, just those facts and background for us. That would be useful. Thank you.
Turning to the submission of Transpower, part 1, Ms. Ratt considers that the PDP should avoid the situation where 2 rules apply to the same activities, and suggests the wording, if any activity is covered by more than 1 rule, then the rule that has the most specific activity applies. I agree with the evidence of Port Taranaki that the suggested statement wouldn't necessarily be helpful, and I consider it would still leave the matter up for debate as to which rule would be more specific. So I do acknowledge the point Ms. Ratt is making, and she's provided us with some really excellent examples of where some of these situations do occur. Ms. Ratt has correctly identified that the PDP is bound by the National Planning Standards structure, and in some cases this has not been avoidable. Again, when we were actually lucky enough to have a preview of the National Planning Standards before it was actually released to the public. The reason being that was the Ministry for the Environment knew how close we were to notification and wanted to ensure that the plan was as compliant as possible with the National Planning Standards. So we spent a lot of time with MFE going through whether something, for example, sits in the subdivision chapter. Does this sit in the coastal chapter? Often it was not clear from the National Planning Standards in the draft that we were exposed to at that time, where was the home for that specific, as using the words of Ms. Ratt, of that most specific activity, where did that actually land? So we spent a lot of time working with MFE for them to guide us. You won't find that guidance in the National Planning Standards because it was difficult sometimes for MFE to even articulate where it needed to go. And we have used the best guidance we possibly could at that time where rules, where their home should be. But having said that though, some of the examples that Ms. Ratt has provided today, I wonder whether some more thought can be just given to whether there are overlaps and whether they strictly need to be worded in the way they are. Some of the examples she has given, they are trying to manage different things. For example, the relocated building that she talked about in the residential zone is about a relocated building, whereas in the natural hazards, that's about hazards in a hazardous area, relocating that building back as part of managed retreat. So they're doing different things, but whether that's clear to the plan user, I think there would be some value in trying to do some analysis over the next 10 days to see if that, if we can shed some more light on where that is happening.
Right, thank you.
In terms of bundling, I actually do like the wording that Ms. Ratt has pointed out to us in the Auckland Unitary Plan, but I do point out that our district plan does provide a similar sort of statement in the how the plan reached general approach chapter. I'll just read it to you very quickly, and I feel like I'm talking very fast to get through these points. So it says, the overall activity status of a proposal will be determined on the basis of all rules which apply to the proposal. When a proposal involves several activities that are subject to multiple rules with different activity status, and/or involves an activity or activities across multiple zones, precincts, areas, overlays, or features, it is appropriate to bundle the activities. And it is appropriate to bundle the activities. The proposal will be assessed on the basis of the most restrictive activity status. So we do have something, and it just is a preference as to what statement you like.
You'll look at that. Ms. Ratt's given us some helpful guidance, so yes.
So
I think with respect to Ms. Ratt's concern was about precisely that situation where you might have a district-wide activity that's subject to an overlay, where the district-wide activity is actually a nationally significant proposition, and that then ought to default or trump the overlay. I think that's the issue that we're talking about.
That's right, and I think in that regard, I think that the Auckland statement probably is more explicit to help with that. So I'll give some thought to that over the next few days.
And the Auckland statement might deal with matters in addition to bundling.
Yes.
Whereas the wording in the current plan
Is
is focused on bundling.
Yes,
There's probably three scenarios I think that the Auckland statement deals with.
That's right. That's right.
It's about prioritization rather than bundling.
So I actually had some comments on LandPro, but I won't go into those today. And I just wanted to point out one thing where we had Mr. Holswich from Ngāti Rāhere speak today about the step-by-step guide. So what Mr. Holswich has raised is an issue that I hadn't thought about before, which is where in the step-by-step guide it alerts plan users to check whether a rule applies, but what it doesn't actually alert plan user is whether a statutory acknowledgement area may be applicable. So I thought that was a really good point he'd picked up on that I hadn't considered before, and I just need to go and see whether we've got scope, whether there is some changes that can be made to that step-by-step guide, and indeed whether it's appropriate as well. So I'd like some time to investigate that point further. However, I think it was sort of, that's a spin out of really what the issue was, and that was more about how the statutory acknowledgement areas are used on our GIS systems and internal systems, and how that triggers notification, which will come up further down the line. And also Joe will provide some more comments on that.
Just on that, it's the first part, it seems more mechanical, and I wonder whether it really needs scope. it's almost a clause 16.
Well, that's a great hint. So yeah, it was
I mean, nothing's writing on it, it's about clarity.
No, but it was a really excellent observation that I really thought of. So with that, I'll finish up.
Thank you. I think there was a question we had about the water bodies and how
yes, there was.
And how, whether you've got an answer to that. Or...
Yes. Well, I haven't got detailed notes on it, and as I wasn't the author on that particular chapter, but what I've done is I've just quickly taken the executive summary from the Section 32A report, and what I did notice in there is that the operative plan identifies 25 priority water bodies as having special significance in terms of natural character and public access and recreational values. But what we've seen is that we've seen a change in the proposed plan where that number of 26 priority water bodies has gone up to 67 significant water bodies, and it also covers a number of the streams and tributaries that were mentioned before. But what we found, the question was, what was the genesis for the change in approach? So just reading directly from the Section 32, this approach, we found that under the operative plan, the approach wasn't effectively recognising the values of water bodies, nor does it effectively protect them or enhance their natural character or maintain or enhance public access to them. The key resource management issues that we found under the operative district plan relate to inappropriate subdivision use and development on or adjacent to water bodies, which can affect biodiversity, ecological, natural character, recreation, access, scenic, amenity and cultural and water quality values around water bodies. There is a demand for public access along lakes, rivers and other water bodies to support recreational opportunity. However, this access could be affected by other values to water bodies, for example, natural character and cultural, as well as the operational requirements of the drawing lands. So the two changes was to introduce the standalone water bodies chapter, update the list of significant water bodies to include 66 new significant water bodies, include building setbacks from water bodies in urban areas, broadening the scope of assessment matters for earthworks in close proximity to water bodies in rural areas and consider those adverse effects, and removal of preferred esplanade reserves and preferred esplanade strips, and adding requirements for the esplanade reserves and strips for subdivision of land along the banks of a significant water body and where allotments of less than 4 hectares created. So that probably is the main
point.
Point of contention.
And we'll look at that in the water
You
body
will,
section.
and there's been some really thorough submissions on the water body chapter, and I'd definitely recommend that would be the place to discuss it.
Thank you very much. Ms. Ritchie. Oh, sorry, was there any questions? Thank you very much.
So if I can just begin with Mr. Holswich's evidence in respect of the Part 1 tongue dependent chapter. So I'm working off his initial evidence. Paragraph 15 notes the request for macron to be added over the name Dahere, and absolutely fine to do that. I thought I had done it already, but if we can understand that, I'll make sure that we'll cover that off. So that's absolutely, we're guided by them about the spelling of their names, so that's fine. Paragraph 17 at the original evidence and paragraphs 7 of the evidence, the summary evidence put in today, talked about the internal GIS system, and I alluded to this and spoke a little bit about it this morning. So prior to, obviously, we had an E-plan, the council has had this internal GIS system for quite some time, and it's used by all several parts of the plan to do different things. And we initially had statutory acknowledgements in that tool, and obviously some of them weren't quite right. So as recently as last year, I think I reviewed that with the help of Te Arawhiti and making sure that we had the data sets, the correct data sets that they provided with us, that we updated. So we're hoping that's up to date now. The tricky thing, as I also alluded to this morning, is that the later settlements in particular, some of the earlier settlements didn't actually refer to very many rivers or streams at all. The later ones, the maps, the OTS maps, are simply a coloured line on a map with the words and tributaries, and its tributaries. And the reason for that is because you'll be aware by now Taranaki has a lot of rivers and streams. There's over 500. And Taranaki Regional Council did the original layer for that data set. But even they can't guarantee that they haven't missed a tributary or two. And I think that was the reason why OTS had put in this wording and its tributaries. They didn't want to miss any. And it was, but they also didn't want to map all of them and then miss some, because that might put them in breach of the treaty. So that's the tricky thing, that there is no data set provided for those rivers and streams. Now, there's an option. Obviously, we can draw polygons around the rivers, which essentially would just be an area around the river and the streams. But then again, we're in this place where we might miss a tributary or whatever. It's a tricky balance to uphold. And I think my understanding is from the resource consent team downstairs that there are lists and there is a reference to the rivers as far as we've got the data from OTS, which is literally just lines showing the significant rivers. And then there are no tributaries unless somebody actually refers to one specifically. So I think the issue always with GIS is how good your data is, how good your metadata is, and where it comes from, and how well we can verify it. So we're open about potentially mapping the rivers and streams, but it could be quite a time-consuming business to do that, and potentially also it is that whole scaling thing. You'd have to literally take everything off to be able to clearly see maybe where the rivers and the streams show up when you're looking on the E-plan. So at the moment, we haven't got all the statutory acknowledgement areas mapped on the E-plan. We could do. It's just a case that we've opted, as the National Planning sort of standards kind of directed us to refer to the legislation. So in the Part 1 Tangata Whenua section, I've got the legislation listed, the settlement legislation, and those links take you to the legislation and to the statutory acknowledgement areas. And there's also links in the, I think, the general approach chapter. Let's just check that for a minute. Sorry, the statutory context chapter of the plan, which is in Part 1. Where we again had links to the statutory acknowledgements areas, where it has a little blurb on statutory acknowledgements and what happens. So there's those two provisions that we have already in there. The council does have a GIS public portal. I'm still trying to find out how often that is updated, but that doesn't have statutory acknowledgement areas in it at the moment either. So it has been used as an internal tool. I think that's kind of the key issue.
Yeah, I'm wondering, who will go first?
Well, I was just going to ask, the NPA, this National Planning Standard doesn't require, not a mandatory manner to map them.
No.
So it's really up to the council to decide what's the most effective way to draw their existence to the attention of potential resource consent applicants. And maybe there's on the stand, I mean, do you have online lodgement for resource consents?
Yes, we do now. I think. Oh, it's coming.
Yeah. Well, I mean, in due course, you might have one of the little boxes that you check at the end. Have you checked to make sure your application does not in relation to any statutory acknowledgement areas? And that then triggers them to go and find that bit at the council webpage, which which has got all of those there, and then they go, oh yeah, okay, it might be to some extent. So I mean, it's all about making the whole thing work together.
That's right. Yeah. So I mean, we could have also potentially added an appendix with lists of the statutory acknowledgement areas and perhaps links. I don't think that was initially favoured. It's also it's a very long list as well. So it was
again, thinking about my practitioner hat, certainly in Hawke's Bay, those statutory acknowledgement areas are mapped on a publicly available tool. So when you go searching for where you are with your application, you can see where the areas are. Quite a lot of the coastal areas reasonably extensive, up to the top of the first ridge type of thing sometimes. So maybe just could double check with some of the other councils. Perhaps Mr. McCoy might be able to assist with that. Yeah, because it is crucial information if you're even thinking about it. Resource consents for many sorts of activities. Having that as best available within the boundaries of your systems. That's the other thing. You can't do what you can't do at the moment.
As much as we can.
Yeah.
Just on there, and I may have misunderstood it, is the identification of statutory acknowledgement areas affecting the status of an activity, or is it more about processes for consultation?
I think
it's just advising.
Yes,
Yeah.
it's not
It's just advice. It's not an RMA matter.
No,
We're not direct.
well, is there a rule that says that you're a certain activity if you're within a statutory acknowledgement area? It's not, is there?
no.
No, it's more about.
Only if the plan included such a rule.
Yeah, and it doesn't, well, okay, that's the question I'm asking. Does the plan include such a rule? It doesn't. This is more about if you need a resource consent for whatever reason, because you trigger a significant water body. Therefore, how is that process and who's on the tent, so to speak?
So it's twice to the heart of the engagement, which to engage you've got to know.
Yeah.
And if you want to engage early, you've got to know early. So yeah, there's certainly a good discussion. Perhaps over the next couple of weeks when you're preparing your reply, you can give us some more thinking about that and just ask around the place. Thank you.
And so the only other discussion that was in Mr. Holswich's report was paragraph 19 of the original evidence and paragraph 8 of the summary evidence. In relation to cultural capacity discussions, I really appreciated Mr. Holswich talking about that today, because I got very much a different view of what that might be when I was thinking about the evidence. So yes, we can try and put something in about that potentially. If that's the case, then maybe that should be extended to cover all of the iwi and hapu. I would think that would be relevant to all of them as well, potentially. So yeah, we could definitely, I'll have a think about that and put it in my right of reply.
Okay. Anything else to comment on?
So this morning we were talking about the website and resource consent applications. There is actually a list of resource consent applications on the website. There's limited info, it just refers to the site and the application number, obviously for privacy reasons. That gets updated about once a month. There's also the resource consent team send a full application to iwi with a covering letter when it's directly obvious that they are affected by an application. And we're trying to put together a better system now that triggers the assessment of statutory acknowledgements. Then I agree there's been a potential lack of process around that, and I think we're still working on getting that system to run more comprehensively.
I know that some councils think that, or their position is that once applications come in and are accepted, in terms of 88A, is it the right one? They become public information. And then some councils have a weekly list of people. You can opt in to say, I'd like to get a copy of those. So every week they'll send an update. I think some councils I work with see that as a not only engagement technique, but also takes away criticisms that people didn't know this public information. So again, have a think about that.
Yes.
Obviously, talk with the consents team and everything else. So that's just a suggestion.
I've just found it on your website. It's interesting. To build a garage inside the 10-metre setback to locate a shipping container on a road. You could lose your life just looking at it.
Well, some people die.
I know what happened. Actually, I know what happened. Auckland started doing this, and then applicants who wanted to sort of prepare their application out of the bright lights of anyone knowing about it would just go through a very, very lengthy pre-application process, because council were of the view that anything pre-lodgement is really just, it's not discoverable. It's between an applicant and a council. The moment it gets lodged and accepted, then it's reviewable. So that's why you had a lot of people spending months not lodging an application, but getting it ready to lodge.
That's their choice.
Yeah.
Okay, anything else?
I've got one point of clarification there, I forgot just before. So the use of the colours in the E-plan are not national planning.
Except for zones.
No, the zone colours are
maps
maps are mandatory colours there, but the use of the colour we've got in our rules, that is MPDC colours, that is our colour palette we've come up with for that. When we flip, so they are based on a traffic light system. They're designed to be simple and easy to understand, and for people to navigate at a glance, you know what colour you are and whether that means go or stop. When we use grey at the top of a rule, that indicates that it's got different activity status underneath. So that was a way of determining that. So that's what that grey colour means. No, not on those colours. No. But you can tell when you step down an activity, say an activity might be permitted in a zone, it'll be green. And then when it goes to restricted discretionary, so the name of the activity will be at the top, but as you step down the different activity status, the colours change to indicate.
That's like country works response on this rag indicated that some of the controlled activities were green.
Green, yes. So we did have that discussion as well. We did
50 shades of green.
We did have that discussion.
That wasn't even free.
Can I ask Joe, can I also ask you a question? Just thinking back to some of the evidence we heard today, comes back to your key issue 3 analysis. And I guess I just wanted to ask whether there is any correlation between the information we've got in the plan under the Tangata Whenua section, which identifies the 6 iwi and then various hapu affiliations. Is there any relationship between that and what the council has identified under section 35 of the Act? Does council maintain a separate register for the purposes of section 35? Do you know what that? Sorry, I'm just duty to keep records of iwi authorities and other groups who represent a hapu or an iwi. So you do have a separate record of that.
And I think Kiwi Relationships manages that.
Okay, and does that correlate with what you've got in the section of the district plan?
I hope it does.
Okay, that's just what I'm asking. I'm just interested to know, because the issue we were faced with Potama today, as I saw it, was very much a contest around recognition, but within a specific statutory framework, where there are definitions that either exclude or include, and I just wanted to get a sense of that.
Yes, at a wider level, I'm aware of that discussion, and we made a decision that we weren't going to mention Potama in this chapter. For all of the information that's come through over the last wee while in terms of their standing, and also the fact that Māngai Hua have taken them off the other iwi list. So we've been guided by that to some extent, and the information that I'm aware of in the background.
So Ngā Hapua Potama are not recorded for the purposes of section 35 as a...
Not anymore, I don't think, no. I think perhaps they were once.
We heard today that they were right up to either 2020 or 2021. I know they were in 2018, checked. So I would like to raise some queries on behalf or to the council team on the submissions we heard today from Hapua Potama. We've received some new information today, including the findings of the tribunal, and we're taking to a number of passages in that findings report. We've asked today for a copy of the plan showing where the Hapua Potama owned, control, manage lands. We've also had from Mr. Greg White copy of the Supreme Court judgment, which was issued last week regarding the status of Hapua Potama in the Mount Messenger notice of requirement litigation or process. So the commissioners will read the information, but in the meantime, if the council in its reply could look particularly at that new information we've received, look back at the section 35 issue about Kiwi authority status, which relates to the Schedule 1 process and the dates and timing of them being recognised as an iwi authority, and provide us any advice you can, because it's an issue that we may have to make some interim findings on going forward. So whatever assistance you could provide in your reply, and don't just limit that to your own advice. Ms. Ritchie, you might have some advice from other officers in council, or legal advice from the council's advising legal counsel.
Thank you.
Thank you. Any other questions for the staff? And I think this process is going to work quite well about the reply back. 2 weeks to go. I know we short-figured things a bit for the hearings tomorrow, but there were some reasons for that, which thank you for cooperating on those. So look, I think we are finished for today. We'll finish with a code here, but there are a couple of matters I want to speak with the hearing administrators about, and you might also have a view. It's about tomorrow's hearing. We're going to have, my understanding, we're going to have both Mr. Thompson and Mr. Heath are going to be here in person. And our proposition is that we will hear for the processes tomorrow. We're starting at 9 o'clock again, aren't we? And we start with, I don't have the hearings schedule in front of me. So is that something we could bring up on the screen? Because
I'm not too sure if there was one, did Julie prepare one for tomorrow? Because I think she was just going to leave it at your discretion.
okay, so there may not be a review. All right.
For today and Wednesday.
So, yeah.
But not for tomorrow. All right. So I'll probably I'll talk to Ms. Straka offline about that. It's just sort of the order of hearing. We might just get a schedule prepared in the morning so we know what we're doing.
Yeah.
I'm minded to hear from Mr. York first, because he's on an expert witness on economic matters, as I see, but I wasn't looking at having him in the hot tub. But again, I'm not sure whether, presuming Brookhaven will be represented as well. Might need to take some advice from the legal counsel on that. Okay, and also on the hearing on Wednesday, the Commissioner McMahon and I are appearing on. There's been another late request to produce a submission on MPDC 122, which is another district council requirement.
That's correct.
Yes.
They won't be appearing, but they must.
Us.
Evidence could be read out.
Read out.
Yeah.
Okay, and we're running out of time, but we might just want to see that area as well, MPDC 122. Once we've got enough light, I'm looking at Owen who's going to be our guide. Yes. Okay.
What's the name of that submitter?
I just saw an email which I haven't been able to attend to.
Miss Easter, there's one submitter, I think.
Yeah.
I wasn't sure of the name of the second one.
Yeah, no, there's another one that's coming.
Cassandra and Stuart Christensen.
Yes.
Christensen is,
okay. So let's do with 122. So we'll try and look at that tonight if we can get a chance. And before we close with the Karakia, I'd just like to acknowledge Mr. Tamati. I think Kevin, is he your cousin or brother?
Yeah, he's my cousin.
Okay, so I've met him at Coronata Marae at Bridge Park. That's Marae there. So nice to make the small connections in this world. So thank you for sitting in and good luck with all the work you're doing. Thank you very much. We'll close. Yeah.
Nice to do that. Ai whakaro, e tai ki ngā tangata I whakaku mai nei tēnā tātou, a tēnā koutou, tūtana mai, papaki mai, whanaunga mai. Whanaunga e te tāmo mai tua, I te kāhui o hinu, I te pōmo mai tātou mai, hari atura. E kākahui taratara kātou ki tēnā whānau, kātou ki are kiko. Hui e te tangata I te rangi nei, hui te iti, hui te rei, kia piri, kia tata, kia rākou nui, kia manu. Koe au ki te tautoko te kakapo o tēnei rā, he nui te kōrero, he nui te mahi, karawi, nā rangatina. Nua reira, he karakia whakamutuna. Tēnei te ara ki runga, ki te aro tēnei tupo, ki te aro tēnei ari, ki te aro tēnei matuai, ki te aro rangi nui e tū nei, ko papatua rapu e tapatua. Kia rau I ura nā tapo wai o tāne tēnei te pō, nau mai te ao, te tūru whakamau, kia tēnā, hui e, tāi ki e. Just closing kind of care was acknowledgement of the people who have gone before us, who climbed the stairways, passing on to the world. It's acknowledged of the work that they've done during their period of time to create the world that we live in today, and we should aspire to be like them. Thank you. And we'll see you at 9 o'clock in the morning.
Yeah.